Or 2, that a reasonable person in the circumstances of Mr. Mew would not have believed he was in danger of imminent death or great bodily harm. Or 3, that a reasonable person in the circumstances of Mr. Mew would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though mistaken. In determining whether Mr. Mew's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed. In Mr. Mew's position, under the circumstances that existed at the time of the alleged offense. The reasonableness of Mr. Mew's beliefs must be determined from his standpoint at the time of the acts and not from the viewpoint of the jury now. If you are satisfied beyond a reasonable doubt that Mr. Mew caused the death of Isaac Schumann with the intent to kill and did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Mew guilty of second-degree intentional homicide. If you are not so satisfied, you must not find Mr. Mew guilty of second-degree intentional homicide, and you should consider whether he is guilty of first-degree reckless homicide, which is also a lesser-included offense of first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of second-degree intentional homicide before considering the offense of first-degree reckless homicide. However, if, after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of second-degree intentional homicide, you should consider whether Mr. Mew is guilty of first-degree reckless homicide. First-degree reckless homicide, as defined in Section 940.02, Parent 1 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being under circumstances that show utter disregard for human life. Before you may find Mr. Mew guilty of first-degree reckless homicide, the state must prove, by evidence that satisfies you beyond a reasonable doubt, that the following 3 elements were present. First, Mr. Mew caused the death of Isaac Schumann. The word cause means that Mr. Mew's act was a substantial factor in producing the death. Second, Mr. Mew caused the death by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and Mr. Mew was aware that his conduct created the unreasonable and substantial risk of death or great bodily harm. You should consider the evidence relating to self-defense in deciding whether Mr. Mew's conduct created an unreasonable risk to another. If Mr. Mew was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that Mr. Mew did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in this case that the risk was unreasonable. The third element, the circumstances of Mr. Mew's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what Mr. Mew was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. You should consider the evidence relating to self-defense in deciding whether the circumstances of Mr. Mew's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that Mr. Mew did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all the evidence in the case that the circumstances of Mr. Mew's conduct showed utter disregard for human life. Consider also Mr. Mew's conduct after the death to the extent that it helps you decide whether or not the circumstances showed utter disregard for human life at the time the death occurred. If you are satisfied beyond a reasonable doubt that Mr. Mew caused the death of Isaac Schumann by criminally reckless conduct, and that the circumstances of the conduct showed utter disregard for human life, you should find him guilty of first-degree reckless homicide. If you are not so satisfied, you must not find him guilty of first-degree reckless homicide, and you should consider whether he is guilty of second-degree reckless homicide, which is a lesser-included offense of first-degree reckless homicide. You should make every reasonable effort to agree unanimously on the charge of first-degree reckless homicide before considering the offense of second-degree reckless homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree reckless homicide, you should consider whether Mr. Mew is guilty of second-degree reckless homicide. Second-degree reckless homicide, as defined in Section 940.06 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being. The difference between first and second-degree reckless homicide is that first-degree offense requires proof of one additional element, that the circumstances of Mr. Mew's conduct showed utter disregard for human life. If you are satisfied beyond a reasonable doubt that all of the elements of first-degree reckless homicide were present, except the element requiring that the circumstances of the conduct showed utter disregard for human life, you should find Mr. Mew guilty of second-degree reckless homicide. In other words, if you are satisfied beyond a reasonable doubt that Mr. Mew caused the death of Isaac Schumann by criminally reckless conduct, you should find him guilty of second-degree reckless homicide. If you are not so satisfied, you must find him not guilty. You are not, in any event, to find Mr. Mew guilty of more than one of those foregoing offenses. Mr. Mew is charged with attempted first-degree intentional homicide of Alexander Martin in count 2, Dante Carlson in count 3, Anthony Carlson in count 4, and Riley Madison in count 5. For each count, you must first consider whether Mr. Mew is guilty of attempted first-degree intentional homicide. If you are not satisfied that Mr. Mew is guilty of attempted first-degree intentional homicide, you must consider whether or not he is guilty of attempted second-degree intentional homicide, or first-degree recklessly endangering safety, or second-degree recklessly endangering safety, which are less serious degrees of attempted criminal homicide. The crimes referred to as attempted first and second-degree intentional homicide and first and second-degree recklessly endangering safety are different degrees of attempted homicide. The degree of attempted homicide defined by the law depends on the facts and the circumstances of each particular case. While the law separates attempted intentional homicides into 2 degrees, there are certain elements which are common to each crime. Both attempted first and second-degree intentional homicide require that Mr. Mew intended to kill another person, and Mr. Mew did acts toward the commission of that crime which indicate unequivocally, under all of the circumstances, that he had formed that intent and would have caused the death of the intended victim except for the intervention of another person or some extraneous factor. First and second degree recklessly endangering safety requires proof that Mr. Mew recklessly endangered the safety of another human. First degree recklessly endangering safety requires proof of one additional element: that the circumstances of Mr. Mew's conduct showed utter disregard for human life. It will also be important for you to consider the privilege of self-defense in deciding which crime, if any, Mr. Mew has committed. For count one, you were instructed on the law of self-defense. The same self-defense standards apply to your consideration of the charges of attempted intentional homicide that are alleged in counts 2 through 5. If you find that the elements of the crime have been proved in this case, the effect of the law of self-defense is as follows. Mr. Mew is not guilty of either attempted first or second degree intentional homicide or first or second degree recklessly endangering safety if he, 1, reasonably believed that he was preventing or terminating an unlawful interference with his person, and 2, reasonably believed the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Mew is guilty of attempted second-degree intentional homicide if he actually believed the force used was necessary to prevent imminent death or great bodily harm to himself, but the belief or the amount of force used was unreasonable. Mr. Mew is guilty of attempted first-degree intentional homicide if he did not actually believe the force used was necessary to prevent imminent death or great bodily harm to himself. Mr. Mew is guilty of first-degree recklessly endangering safety if he recklessly endangered the safety of another human under circumstances that showed utter disregard for human life. Mr. Mew is guilty of second-degree recklessly endangering safety if he recklessly endangered the safety of another human. Because the law provides that it is the state's burden to prove all the facts necessary to constitute a crime beyond a reasonable doubt, you will not be asked to make a separate finding on whether Mr. Mew acted in self-defense. Instead, you will be asked to determine whether the state has established the necessary facts to justify a finding of guilt for attempted first or second degree intentional homicide or first or second degree recklessly endangering safety. If the state does not satisfy you that those facts are established by evidence, you will be instructed to find Mr. Mew not guilty. The elements of each crime will now be defined to you in greater detail. Before you may find Mr. Mew guilty of attempted first-degree intentional homicide, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following 3 elements were present. First, Mr. Mew intended to kill the named person. For count 2, the state must prove Mr. Mew intended to kill Alexander Martin. For count 3, the state must prove that Mr. Mew intended to kill Dante Carlson. For count 4, the state must prove that Mr. Mew intended to kill Anthony Carlson. For count 5, the state must prove that Mr. Mew intended to kill Riley Madison. Intent to kill means that Mr. Mew had the mental purpose to take the life of another human being or was aware that his conduct was practically certain to cause the death of another human being. The second element, Mr. Mew did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of the named person except for the intervention of another person or some other extraneous factor. Unequivocally means that no other interference or, Unequivocally means that no other inference or conclusion can reasonably and fairly be drawn from Mr. Mew's acts under the circumstances. Another person means anyone but Mr. Mew and may include the intended victim. An extraneous factor is something outside Mr. Mew's knowledge or control. The third element, Mr. Mew did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. While the law requires that Mr. Mew acted with intent to kill, it does not require that the intent exists for any particular length of time before the act is committed. The act need not be brooded over, considered, or reflected upon for a week, a day, an hour, or even a minute. There need not be any appreciable time between the formation of the intent and the act. The intent to kill may be formed at any time before the act, including the instant before the act, and must continue to exist at the time of the act. You cannot look into a person's mind to find intent. Intent to kill must be found, if found at all, from Mr. Mew's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent. Intent should not be confused with motive. While proof of intent is necessary to a conviction, proof of motive is not. Motive refers to a person's reason for doing something. While motive may be shown as a circumstance to aid in establishing guilt of a defendant, the state is not required to prove Mr. Mew's motive in order to convict. Evidence of motive does not by itself establish guilt. You should give it the weight you believe it deserves under all of the circumstances. The third element of attempted first-degree intentional homicide requires that Mr. Mew did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove either, 1, Mr. Mew did not actually believe he was in imminent danger of death or great bodily harm, or 2, that Mr. Mew did not actually believe the force used was necessary to prevent imminent death or, 2, that Mr. Mew did not actually believe the force used was necessary to prevent imminent danger of death or great bodily harm to himself. When attempted first-degree intentional homicide is considered, the reasonableness of Mr. Mew's belief is not an issue. You are to be concerned only with what Mr. Mew actually believed. Whether these beliefs are reasonable is important only if you later consider whether Mr. Mew is guilty of attempted second-degree intentional homicide. If you are satisfied beyond a reasonable doubt that Mr. Mew intended to kill the person named in each count, Alexander Martin for count 2, Dante Carlson for count 3, Anthony Carlson for count 4, and Riley Madison for count 5, and that Mr. Mew's acts demonstrated unequivocally that he intended to kill and would have killed the named person except for the intervention of another person or some other extraneous factor, and that Mr. Mew did not actually believe that the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Mew guilty of attempted first-degree intentional homicide. If you are not so satisfied, you must not find him guilty of attempted first-degree intentional homicide, and you must consider whether Mr. Mew is guilty of attempted second-degree intentional homicide, as defined in Section 940.05 of the Criminal Code of Wisconsin, which is a lesser included offense of attempted first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of attempted first-degree intentional homicide before considering the offense of attempted second-degree intentional homicide. However, if after a full and complete consideration of the evidence, you conclude that further deliberation would not result in a unanimous agreement on the charge of attempted first-degree intentional homicide, you should consider whether Mr. Mew is guilty of attempted second-degree intentional homicide. Before you may find Mr. Mew guilty of attempted second-degree intentional homicide, the state must prove by evidence which satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Mew intended to kill the named person. Second, Mr. Mew did acts which demonstrate unequivocally, under all of the circumstances, that he had formed the intent and would have caused the death of the named person, except for the intervention of another person or some extraneous factor. Third, Mr. Mew did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. You have already been instructed on the definitions of intent to kill, unequivocally, another person, and extraneous factor. The same definitions apply to your consideration of attempted second-degree intentional homicide. The third element of attempted second-degree intentional homicide requires that Mr. Mew not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe that the force used was necessary to prevent imminent death or great bodily harm to himself. This requires that the state prove any one of the following. 1, that a reasonable person in Mr. Mew's circumstances would not have believed that he was preventing or terminating an unlawful interference with his person, or 2, that a reasonable person in Mr. Mew's circumstances would not have believed he was in danger of imminent death or great bodily harm, or 3, that a reasonable person in Mr. Mew's circumstances would not have believed that the amount of force used was necessary to prevent imminent death or great bodily harm to himself. A belief may be reasonable even though mistaken. In determining whether Mr. Mew's beliefs were reasonable, the standard is what a person of ordinary intelligence and prudence would have believed in Mr. Mew's position under the circumstances that existed at the time of the alleged offense. The reasonableness of Mr. Mew's beliefs must be determined from the standpoint of Mr. Mew at the time of his acts and not from the viewpoint of the jury now. If you are satisfied beyond a reasonable doubt that Mr. Mew intended to kill the person named in each count, Alexander Martin for count 2, Dante Carlson count 3, Anthony Carlson count 4, Riley Madison for count 5, and that Mr. Mew's acts demonstrated unequivocally that he intended to kill and would have killed the named person except for the intervention of another person or some extraneous factor, and that Mr. Mew did not reasonably believe that he was preventing or terminating an unlawful interference with his person, or did not reasonably believe the force used was necessary to prevent imminent death or great bodily harm to himself, you should find Mr. Mew guilty of attempted second-degree intentional homicide. If you are not so satisfied, you must not find him guilty of attempted second-degree intentional homicide, and you must consider whether Mr. Mew is guilty of first-degree recklessly endangering safety, as defined in Section 941.30 of the Criminal Code of Wisconsin, which is a lesser-included offense of attempted first-degree intentional homicide. You should make every reasonable effort to agree unanimously on the charge of attempted second-degree intentional homicide before considering the offense of first-degree recklessly endangering safety. However, if after full and complete consideration of the evidence, you conclude that further deliberations would not result in unanimous agreement on the charge of attempted second-degree intentional homicide, you should consider whether Mr. Mew is guilty of first-degree recklessly endangering safety. First-degree recklessly endangering safety, as defined in Section 941.30, Parent 1 of the Criminal Code of Wisconsin, is committed by one who recklessly endangers the safety of another human being under circumstances that show utter disregard for human life. Before you may find Mr. Mew guilty of first-degree recklessly endangering safety, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following three elements were present. First, Mr. Mew endangered the safety of another human being. Second, Mr. Mew endangered the safety of another by Mr. Mew endangered the safety of another by criminally reckless conduct. Criminally reckless conduct means the conduct created a risk of death or great bodily harm to another person, and the risk of death or great bodily harm was unreasonable and substantial, and Mr. Mew was aware that his conduct created the unreasonable and substantial risk of death or great. You should also consider the evidence relating to self-defense in deciding whether Mr. Mew's conduct created an unreasonable risk to another. If Mr. Mew was acting lawfully in self-defense, his conduct did not create an unreasonable risk to another. The burden is on the state to prove beyond a reasonable doubt that Mr. Mew did not act lawfully in self-defense, and you must be satisfied beyond a reasonable doubt from all the evidence in the case that the risk was unreasonable. The third element, the circumstances of Mr. Mew's conduct showed utter disregard for human life. In determining whether the circumstances of the conduct showed utter disregard for human life, consider these factors: what Mr. Mew was doing, why he was engaged in that conduct, how dangerous the conduct was, how obvious the danger was, whether the conduct showed any regard for life, and all other facts and circumstances relating to the conduct. We should also consider the evidence relating to self-defense in deciding whether the circumstances of Mr. Mew's conduct showed utter disregard for human life. The burden is on the state to prove beyond a reasonable doubt that Mr. Mew did not act lawfully in self-defense. And you must be satisfied beyond a reasonable doubt from all of the evidence in this case that the circumstances of Mr. Mew's conduct showed utter disregard for human life. Consider also Mr. Mew's conduct after the act alleged to have endangered safety to the extent that it helps you to decide whether or not the circumstances showed utter disregard for human life at the time the act allegedly to have endangered safety occurred. If you are satisfied beyond a reasonable doubt that Mr. Mew recklessly endangered the safety of another, those named in each count, Alexander Martin for count 2, Dante Carlson count 3, Anthony Carlson count 4, and Riley Madison count 5, and the circumstances of the conduct showed utter disregard for human life, you should find him guilty of first-degree recklessly endangering safety. If you are not so satisfied, you must not find him guilty of first-degree recklessly endangering safety, and you should consider whether he is guilty of second-degree recklessly endangering safety, which is a lesser-included offense of first-degree recklessly endangering safety. You should make every reasonable effort to agree unanimously on the charge of first-degree recklessly endangering safety before considering the offense of second-degree recklessly endangering safety. However, if, after full and complete consideration of the evidence, you conclude that further deliberation would not result in unanimous agreement on the charge of first-degree recklessly endangering safety, you should consider whether Mr. Mew is guilty of second-degree recklessly endangering safety. Second-degree recklessly endangering safety, as defined in Section 941.30, Parent 2 of the Criminal Code of Wisconsin, is committed by one who recklessly causes the death of another human being. The differences between first and second-degree recklessly endangering safety is that the first-degree offense requires proof of one additional element: that the circumstances of Mr. Mew's conduct showed utter disregard for human life. If you are satisfied beyond a reasonable doubt that all of the elements of first-degree recklessly endangering safety were present, except the element requiring that the circumstances of the conduct showed utter disregard for human life, you should find Mr. Mew guilty of second-degree recklessly endangering safety. In other words, if you are satisfied beyond a reasonable doubt that Mr. Mew endangered the safety of Alexander Martin, Dante Carlson, Anthony Carlson, or Riley Madison by criminally reckless conduct, you should find him guilty of second-degree recklessly endangering safety. If you are not so satisfied, you must find him not guilty. You are not, in any event, to find Mr. Mew guilty of more than one of the foregoing offenses for each count.
Sorry, Judge. Could we take a brief break, please?
Yes, please take the jury out.
All rise for the jury.
Let's return in 5 minutes, 9:40. What's that? No, I just wait. I think I speak for everyone in the courtroom. That was a well-timed break. All right, is everyone ready to listen to the judge talk some more? All right. I'm picking up on page 20. In count 6 of the information, the judge alleged that Mr. Mew committed battery. Battery, as defined in section 940.19, parent 1 of the Criminal Code of Wisconsin, is committed by one who causes bodily harm to another by an act done with the intent to cause bodily harm to that person or another without the consent of the person so harmed. Before you may find Mr. Mew guilty of this offense, the state must prove by evidence that satisfies you beyond a reasonable doubt that the following 4 elements were present.
Judge, can we approach quick?
Yes? Every lawyer loves to tell the judge he made a mistake. I made a mistake. In count 6 of the information, the state alleged that Mr. Mew committed battery. So let me get to the elements. First, Mr. Mew caused bodily harm to Madison Cohen. The word cause means that Mr. Mew's act was a substantial factor in producing the bodily harm. Bodily harm means physical pain or injury, illness, or any impairment of physical condition. Second element, Mr. Mew intended to cause bodily harm to Ms. Cohen. Intent to cause bodily harm means that Mr. Mew had the mental purpose to cause bodily harm to another human being, or was aware that his conduct was practically certain to cause bodily harm to another human being. The third element, Mr. Mew caused bodily harm without the consent of Ms. Cohen. The fourth element, Mr. Mew knew that Ms. Cohen did not consent. You cannot look into a person's mind to find intent and knowledge. Intent and knowledge must be found, if found at all, from Mr. Mew's acts, words, and statements, if any, and from all of the facts and circumstances in this case bearing upon intent and knowledge. The state must prove by evidence that satisfies you beyond a reasonable doubt that Mr. Mew did not act lawfully in self-defense. You were instructed on the law of self-defense in count 1. The same self-defense standards apply to your consideration of the charge of battery alleged in count 6. If you are satisfied beyond a reasonable doubt that all 4 elements of battery have been proved and that Mr. Mew did not act lawfully in self-defense, you should find him guilty. If you are not so satisfied, you must find him not guilty. The information alleges not only that Mr. Mew committed the crimes charged in counts 1 through 6, but also that he did so while using a dangerous weapon. If you find Mr. Mew guilty on any of these counts, you must answer the following question. Did Mr. Mew commit the crime while using a dangerous weapon? Dangerous weapon means any device or instrumentality which, in the manner it is used or intended to be used, is likely to produce death or great bodily harm. Again, great bodily harm means injury which creates a substantial risk of death or which causes serious permanent disfigurement or which causes a permanent or protracted loss or impairment of the function of any bodily member or organ or other serious bodily injury. Before you may answer this question, yes, you must be satisfied beyond a reasonable doubt that Mr. Mew committed the crime while using a dangerous weapon. If you are not so satisfied, you must answer the question no. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes every person charged with the commission of an offense to be innocent. This presumption requires a finding of not guilty unless in your deliberations you find it is overcome by evidence that satisfies you beyond a reasonable doubt that Mr. Mew is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you beyond a reasonable doubt that Mr. Mew is guilty. If you can reconcile the evidence upon any reasonable hypothesis consistent with Mr. Mew's innocence, you must do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give Mr. Mew the benefit of every reasonable doubt, you are not to search for doubt. You are to search for the truth and give Mr. Mew the benefit of any reasonable doubt that remains after carefully considering all the evidence in this case. You are to decide the case solely on the evidence offered and received at trial. Evidence is, first, the sworn testimony of witnesses, both on direct and cross-examination, regardless of who called the witness. Second, the exhibits the court has received, whether or not an exhibit goes to the jury room. Third, any facts to which the lawyers have agreed or stipulated, or which the court has directed you to find. Anything you may have seen or heard outside the courtroom is not evidence. It is not necessary that every fact be proved directly by a witness or an exhibit. A fact may be proved indirectly by circumstantial evidence. Circumstantial evidence is evidence from which a jury may logically find other facts, according to common knowledge and experience. Circumstantial evidence is not necessarily better or worse than direct evidence. Either type of evidence can prove a fact. Whether evidence is direct or circumstantial, it must satisfy you beyond a reasonable doubt that Mr. Mew committed the offense before you may find him guilty. Evidence has been presented relating to Mr. Mew's conduct after the alleged crime was committed. Whether the evidence shows a consciousness of guilt and whether consciousness of guilt shows actual guilt are matters exclusively for you to decide. Remarks of the attorneys are not evidence. If their remarks suggested certain facts not in evidence, disregard the suggestion. An exhibit becomes evidence only when received by the court. An exhibit marked for identification and not received is not evidence. An exhibit received is evidence whether or not it goes to the jury room. Attorneys for each side have the right and the duty to object to what they consider are improper questions asked of witnesses and to the admission of other evidence which they believe is not properly admissible. You should not draw any conclusions from the fact an objection was made. By allowing testimony or other evidence to be received over the objection of counsel, the court is not indicating any opinion about the evidence. You, the jurors, are the judges of the credibility of the witnesses and the weight of the evidence. Disregard entirely any question that the court did not allow to be answered. Do not guess at what the witness's answer might have been. If the question itself suggested that certain information might be true, ignore the suggestion and do not consider it as evidence. The weight of the evidence does not depend on the number of witnesses on each side. You may find that the testimony of one witness is entitled to the greater weight than that of another witness or even of several other witnesses. In weighing the evidence, you may take into account matters of your common knowledge and your observation. Start over. In weighing the evidence, you may take into account matters of your common knowledge and your observations and experience in the affairs of life. It is the duty of the jury to scrutinize and to weigh the testimony of witnesses and to determine the effect of the evidence as a whole. You are the sole judges of the credibility, that is, the believability, of the witnesses and of the weight to be given to their testimony. In your determination of credibility, you must avoid bias, conscious or unconscious, based on the witness's age, race, national origin, religion, ability, gender identity, sexual orientation, education, income level, or any other personal characteristic. In determining the credibility of each witness and the weight you give to the testimony of each witness, consider these factors. Whether the witness has an interest or lack of interest in the result of this trial, the witness's conduct, appearance, and demeanor on the witness stand, the clearness or lack of clearness of the witness's recollections, the opportunity the witness had for observing and for knowing the matters the witness testified about, the reasonableness of the witness's testimony, the apparent intelligence of the witness, bias or prejudice, if any, has been shown, possible motives for falsifying testimony, and all other facts and circumstances during the trial which tend either to support or to discredit the testimony. Then give to the testimony of each witness the weight you believe it should receive. There is no magic way for you to evaluate the testimony. Instead, you should use your common sense and experience. In everyday life, you determine for yourselves the reliability of things people say to you. You should do the same thing here. We've now reached the stage where the attorneys will deliver their closing arguments. Consider carefully the closing arguments of the attorneys, but their arguments and conclusions and opinions are not evidence. Draw your own conclusions from the evidence and decide upon your verdict according to the evidence under the instructions given to you by the court. First, we'll hear from Mr. Anderson. When he's done, we'll take a short break. After that, we'll hear from Mr. Sharafazi, and then Mr. Anderson will be permitted to give a short rebuttal. Mr. Anderson.
Thank you, Judge.
Absolutely senseless and horrific acts of violence. And all Nikolai Mew had to do was walk away. All he had to do was walk away. That's what you've seen in this case. You saw he told Lieutenant Hart, "They told me I can't run away." Obviously not true. Think about the result of his actions. Everything you've seen in this trial, the horrific injuries, the death of Isaac. Why didn't he just walk away? His only explanation when testifying was, "I stood my ground. I stood my ground." First of all, Wisconsin is not a stand your ground state.
Objection. Overruled.
I'll talk about that specifically from your jury instructions. Second, that's not true, as I'll show you. He didn't just stand his ground. I'm not going to defend the actions of the boys who testified. It was cruel what they were calling Nikolai. They shouldn't have been mocking him, calling him predator, raper. But their conduct did not justify what Nikolai did. You heard from Alina, Isaac's mother, about her son Isaac. He was 17 years old when he was killed. He enjoyed golfing, spending time with friends. Recently started a new business, detailing cars. He was an honor student looking forward to going to college. His death was senseless. One of the things defense said in the beginning of trial in their opening was they're glad there's a video. So are we. Without the video, Nikolai would have slipped away. The only reason he was apprehended was because law enforcement had that screenshot of him. The video doesn't fade with time. It's not biased, not influenced by alcohol. As I told you in the beginning of this case, the violent episode from the video is about 25 seconds, from the point he punches Madison until you see him walking off after stabbing 5 people. He's not seen, Nikolai is not seen in that video for 8 to 9 seconds until the point you see him walking away. You don't see him stab Dante. Some of you may have wondered why we called Marion Davis. Certainly it wasn't for his eyewitness testimony, but he took a video. He took a video that captured a different angle than Juwan's video. It's grainy, it's difficult to see, but you can see enough.
Has been a motion to exclude witnesses, so as the state begins with its case in chief, keep that in mind that they are not permitted to observe the trial proceedings, including the live stream. The only exception would be for a witness if they statutorily qualify as a victim, then they are permitted to observe the proceedings. So each witness is going to be questioned whether or not they've observed any trial proceedings, and I would instruct the state and then following the defense, if they have witnesses, to make sure that the exclusionary rule is followed. Does the state have any questions on that matter?
Your Honor, the state would just clarify and just make counsel in the court aware. It's the state's understanding that through the Constitution and statutorily, victims have a right to remain in the courtroom throughout the proceedings, regardless of whether or not they are victims. And we have discussed that with defense counsel and made the court aware of who we think there may be a crossover with, meaning individuals that may be present and also witnesses. But statutorily, they would have the right to be here. So including any of the defendant's children, as well as, since they were Tammy's children, as well as siblings, sometimes grandparents. The court made a ruling last year in the Lori Vallow case. I think if we're following a similar guideline, those are the individuals that we would just note for the record may be present at times, but should have the right to be present throughout the proceedings. In addition, I would just note for the record that we do have our case agent who will be present for the duration of the proceedings, and that's Chief Deputy Vince Kaikamani.
Okay, and the state's permitted their case agent as it relates to victims. The court agrees they are permitted to see the proceedings, including if they are a witness. We would take up on a witness by witness basis whether or not they fall within the statutory qualifications permitting that. And I know the state's aware of the issue. We'll make rulings tested as to whether or not they would qualify and later called to testify. Mr. Pryor from the defense, any further comment or questions on the exclusionary ruling?
Nothing further, Your Honor.
Okay, thank you. All right, this time then we will have the jurors brought in.
Yes, sir. All rise. Oh, the jury is present and accounted for.
All right, thank you, Mr. Bale. Please be seated. All right, thank you, ladies and gentlemen of the jury. We're on the record on Fremont County case CR 22-21-1623, State of Idaho versus Chad Guy Daybell. We're ready to proceed with opening arguments and initial instructions this morning to you as jurors. The court notes that the prosecution is present as well as the defendant and the defense attorney representing him as well. We have qualified this panel of 18 jurors consisting of our 12 jurors with 6 alternates, and they are now seated for trial. Let me start with the state and ask, will the state agree that the jury has now been properly seated and ready to be sworn?
Yes, Your Honor, thank you.
Will the defense agree as well?
Yes, Your Honor.
Thank you. All right, ladies and gentlemen of the jury, thank you for returning this morning. You're now seated as jurors in the case before us. As previously been told, I'm Stephen W. Boyce, the District Judge of Fremont County in charge of this courtroom trial. I'll briefly reintroduce you to some of our court personnel assisting here today. Shannon Holstein, seated to my right, is the clerk who is keeping minutes of the trial proceedings, will be marking trial exhibits and administering oaths to you as jurors and to the witnesses. We do have our courtroom bailiffs as well who assist with keeping order in the courtroom and helping the jury move about where they're supposed to throughout the day, and then enforcing any conduct orders we have in effect here for the trial. Our court reporter today, Amy Bland, is taking a stenographic record of everything said during the trial proceedings, and my staff attorney, Courtney Stallings, is seated to the far right, who assists me with legal research and administrative matters that come up throughout each day of trial. Each one of you has been qualified, examined, and selected to serve as a juror of this court. The clerk will now have a roll call of our seated jurors. Please, Madam Clerk, if you would conduct the roll call. As to each juror, once your juror number is announced, please just indicate present or here verbally so we acknowledge that on the record, Madam Clerk.
Juror 27, present. Juror 219,
Here.
juror 505,
Here.
juror 631.
Here.
Juror 653.
Here.
Juror 686,
Present.
juror 752,
Present.
juror 1680, present. Juror 823,
Here.
juror 1358,
Here.
juror 1365, yeah. Juror 716, yeah. Juror 751,
Here.
juror 997,
Here.
juror 1078, juror 1577, here. Juror 1271, juror 1382, present.
Thank you, Madam Clerk. This case has been brought by the state of Idaho. I'll sometimes refer to the state as the prosecution. State is here represented in this trial by Lindsay Blake, Fremont County prosecutor. Ms. Blake, could you please stand briefly? Also, Rob Wood is the Madison County prosecutor. Ingrid Beatty is a special assistant prosecutor. And Rocky Wixom is a Fremont County deputy prosecutor. The defendant in this case, Mr. Daybell, is represented by his attorney, John Pryor. Thank you, counsel. In a few moments, the clerk will read you a redacted version of the amended indictment in this case. That document is not to be considered as evidence. It sets forth the charges against the defendant. You must not consider it as evidence of guilt and not be influenced by the fact that charges have been filed. Mr. Daybell has pled not guilty to the charges contained in the amended indictment. And please remember, again, it's a description of charges. It is not evidence. Under our law and system of justice, every defendant is presumed to be innocent. This means two things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crimes beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from a lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. The duty of the jury is to determine the facts and then apply the law set forth in the instructions I will later give you to those facts. In this way, you will decide the case. In applying the court's instructions as to the controlling law, you must follow those instructions regardless of your opinion of what the law is or what the law should be or what any lawyer may state the law to be. During this course of the trial, including opening statements, you're instructed that you are not to discuss this case among yourselves or with anyone else, including using the internet or social media or any other form of communication, electronic or otherwise. Do not conduct any personal investigation or look up any information from any source, including the internet. And do not form an opinion as to the merits of the case until after the case has been submitted to you for your determination. The court's given you that instruction now multiple times, and I will continue to give you that instruction. And again, that's not because I don't think you're not paying attention. It's just important enough. We'll keep reiterating that. And I will note we received the juror affirmations today from each of the jurors indicating they have followed that instruction. So thank you for that. At this time then, the next matter we'll take up is to have this jury placed under oath for trial. At this time then, Madam Clerk, if you're ready to administer the oath, I'll have the jurors stand and be placed under oath. When you stand, then please raise your right hands.
You solemnly swear or affirm that you will try the cause now on trial and a true verdict rendered herein according to the law and the evidence, so help you God.
All right, thank you. Please be seated. All right, the jurors have already been advised of some of our trial procedures in this case, and I'll just give you some additional general information here. Our normal schedule is to run trial from 8:30 each day until 3:30. At times that will need to be modified for certain reasons. Sometimes we have matters to be argued outside of your presence. Sometimes during the recesses, they may seem to go long because we're conducting other court business outside of your presence. But we will take recesses through the morning and also in the afternoon. If anyone is uncomfortable, needs a break or recess for some specific reason, please notify the bailiff and we'll do our best to accommodate each of you and keep you comfortable while you're here. In addition, if anyone has any kind of accommodations they need, for example, assistance with a hearing device, other matters, please notify the bailiff again, and we want to make sure you are as comfortable as you can be and able to be alert and attentive throughout the presentation of evidence in the case. These seats that you have been assigned to at this time will be your specific seat throughout the trial. Please return to that same assigned seat each day or after each break so that we are able to determine who's here and if someone's not for some reason, who's not here. If there are interruptions at times during the trial, I know that can be frustrating, but we'll work our best to keep those to a minimum, move the trial as long as efficiently as possible, but at times it just takes time to hear motions that are necessary outside of your presence. And then the courtroom and your location for deliberations, as well as during the trial where you'll be held. We've provided, of course, access to restrooms and other needs you may have. I'll address your compensation here. State law allows you for $10 a day for your jury service. However, after 5 days, that bumps up to $40 a day. So this trial is expected to go some time. You'll likely get into that increased range of compensation, and that's pursuant to Idaho Code 2215. You're also entitled, I believe, to a mileage reimbursement for travel each day, and that can further be explained to you if you have any questions. Also, you may notice from time to time, or a lot of the time, I'm looking at monitors here during the trial. And you have case information here and availability to access and research things from the bench. And so if you notice me looking at those monitors, it's generally to assist me in trial issues that come up. At this time, then the court will provide the jury with some additional jury instructions. As I read through these, it's somewhat lengthy, and I will notify you that you don't have to necessarily memorize everything I'm saying. When the trial is concluded and you deliberate, you will have printed copies of these instructions to return to for reference. And if you'll give me just a moment here, I have a brief inquiry to make with my staff attorney. All right, thank you. Now that you've been sworn as jurors to try this case, I'll go over with you what will be happening. I will describe how the trial will be conducted and what we will be doing. At the end of the trial, I'll give you more detailed guidance on how you are to reach your decision. Because the state has the burden of proof, it goes first. After the state's opening statement, the defense may make an opening statement or may wait until the state has presented its case. The state will offer evidence that it says will support the charges against the defendant. The defense may then present evidence but is not required to do so. If the defense does present evidence, the state may then present rebuttal evidence. This is evidence offered to answer the defense's evidence. After you have heard all of the evidence, I'll give you additional instructions on the law. After you've heard the instructions, the state and the defense will each be given time for closing arguments. In their closing arguments, they will summarize the evidence to help you understand how it relates to the law. Just as the opening statements are not evidence, neither are the closing arguments. After the closing arguments, you will leave the courtroom together to make your decision. During your deliberations, you will have with you my instructions, the exhibits admitted into evidence, and any notes taken by you in court. The defendant is charged by the state of Idaho with a violation of law. The charges against the defendant are contained in the amended indictment. The amended indictment is simply a description of the charges. It is not evidence. Jury instruction number 3. The defendant, Chad Daybell, has been charged in the amended indictment with certain counts of entering into a conspiracy with Lori Daybell and or Alex Cox and or other co-conspirators. The crime of conspiracy involves an agreement by 2 or more persons to commit a crime. You must only consider the evidence against the defendant, Chad Daybell, in this case, and should not speculate as to any other case or legal proceedings involving any alleged co-conspirators. You must remember that the defendant, Chad Guy Daybell, has the presumption of innocence, and you must consider his guilt or innocence based solely on the evidence provided in this case. Instruction number 4. It is alleged that the crimes charged were committed on or about or on or between a certain date. If you find a crime was committed, the proof need not show that it was committed on that precise date. Instruction number 5. Under our law and system of justice, the defendant is presumed to be innocent. Presumption of innocence means 2 things. First, the state has the burden of proving the defendant guilty. The state has that burden throughout the trial. The defendant is never required to prove his innocence, nor does the defendant ever have to produce any evidence at all. Second, the state must prove the alleged crime beyond a reasonable doubt. A reasonable doubt is not a mere possible or imaginary doubt. It is a doubt based on reason and common sense. It may arise from a careful and impartial consideration of all the evidence or from lack of evidence. If after considering all the evidence you have a reasonable doubt about the defendant's guilt, you must find the defendant not guilty. Jury instruction number 6. A defendant in a criminal trial has a constitutional right not to be compelled to testify. The decision whether to testify is left to the defendant, acting with the advice and assistance of the defendant's lawyer. You must not draw any inference of guilt from the fact that the defendant may not testify, nor should this fact be discussed by you or enter into your deliberations in any way. Jury instruction number 7. If during the trial I may say or do anything which suggests to you that I am inclined to favor the claims or positions of any party, you will not permit yourself to be influenced by any such suggestion. I will not express nor intend to express, nor will I intend to intimate any opinion as to which witnesses are or are not worthy of belief, what facts are or are not established, or what inferences should be drawn from the evidence. If any expression of mine seems to indicate an opinion relating to any of these matters, I will instruct you to disregard it. Jury instruction number 8. Your duties are to determine the facts, to apply the law set forth in my instructions to those facts, and in this way to decide the case. In doing so, you must follow my instructions regardless of your own opinion of what the law is or should be, or what either side may state the law to be. You must consider them as a whole, not picking out one and disregarding others. The order in which the instructions are given has no significance as to their relative importance. The law requires that your decision be made solely upon the evidence before you. Neither sympathy nor prejudice should influence you in your deliberations. Faithful performance by you of these duties is vital to the administration of justice. In determining the facts, you may consider only the evidence admitted in this trial. This evidence consists of the testimony of the witnesses, the exhibits offered and received, and any stipulated or admitted facts. The production of evidence in court is governed by rules of law. At times during the trial, an objection may be made to a question asked a witness, or to a witness's answer, or to an exhibit. This simply means I'm being asked to decide a particular rule of law. Arguments on the admissibility of evidence are designed to aid the court and are not to be considered by you nor affect your deliberations. If I sustain an objection to a question or to an exhibit, the witness may not answer the question, or the exhibit may not be considered. Do not attempt to guess what the answer might have been or what the exhibit might have shown. Similarly, if I tell you not to consider a particular statement or exhibit, you should put it out of your mind and not refer to it or rely on it in your later deliberations. During the trial, I may have to talk with the parties about the rules of law which should apply to this case. Sometimes that will occur over on the corner there, and we do have a device here that whites out the noise so you can't hear us speaking there. At other times, I'll excuse you from the courtroom so that you can be comfortable while we work out any problems with evidence. You are not to speculate about any such discussions. They are necessary from time to time to help the trial run more smoothly. Some of you have probably heard the terms circumstantial evidence, direct evidence, and hearsay evidence. Do not be concerned with these terms. You are to consider all the evidence admitted in this trial. However, the law does not require you to believe all of the evidence. As the sole judges of the facts, you must determine what evidence you believe and what weight you attach to it. There is no magical formula by which one may evaluate testimony. You bring with you to this courtroom all the experience and background of your lives. In your everyday affairs, you determine for yourselves whom you believe, what you believe, and how much weight you attach to what you are told. The same considerations that you use in your everyday dealings in making these decisions are the considerations which you must apply in your deliberations. In deciding what you believe, do not make your decisions simply because more witnesses may have testified one way than the other. Your role is to think about the testimony of each witness you heard and decide how much you believe of what the witness had to say. A witness who has special knowledge in a particular matter may give an opinion on that matter. In determining the weight to be given such an opinion, you should consider the qualifications and credibility of the witness and the reasons given for the opinion. You are not bound by such opinion. Give it the weight, if any, to which you deem it entitled. During instruction number 9, at the conclusion of the trial, you will decide as to each charge whether the state has proved the defendant guilty beyond a reasonable doubt. The subject of penalty or punishment is not to be discussed or considered by you in making these decisions. That is a matter which must not in any way affect your verdict. Jury instruction number 10. The state is seeking the death penalty in this case. If the defendant is convicted of murder in the first degree, there will then be a separate sentencing phase of the trial. At that sentencing phase, additional evidence may be presented and the jury will be given additional instructions. At the conclusion of that hearing, the jury will then decide if the defendant will be sentenced to death. If the jury decides that the defendant will not be sentenced to death, either the defendant will be sentenced to a term of life imprisonment without the possibility of parole, or the judge will sentence the defendant to a term of life imprisonment during which the defendant could not be paroled for at least 10 years and possibly for life. Jury instruction number 11. If you wish, you may take notes to help you remember what witnesses said. If you do take notes, please keep them to yourself until after you and your fellow jurors go to the jury room to decide the case. You should not let note-taking distract you so that you do not hear other answers by witnesses. When you leave at night, you'll leave your notes here with the bailiffs. If you do not take notes, you should rely on your own memory of what was said and not be overly influenced by the notes of other jurors. In addition, you cannot assign one person the duty of taking notes for all of you. Jury instruction number 12. It is important that as jurors and officers of this court, you obey the following instructions at any time you leave the jury box, whether it be for recesses of the court during the day or when you leave the courtroom to go home at night. First, do not talk about the case among yourselves or with anyone else during the course of the trial. You should keep an open mind throughout the trial and not form or express an opinion about the case. You should only reach your decision after you have heard all the evidence, after you've heard my final instructions, and after the final arguments. You may discuss this case with the other members of the jury only after it is submitted to you for your decision. All such discussions should take place in the jury room. Second, do not let any person talk about the case in your presence. If anyone does talk about it to you, tell them you're a juror of the case. If they won't stop talking, then report that to the bailiff or courtroom staff here as soon as you're able to do that. You should not tell your fellow jurors about what has happened. Third, during this trial, do not talk with any of the parties, their lawyers, or any witnesses. By this, I mean not only do not talk about the case, but do not talk at all, even to pass the time of day. In no other way can all parties be assured of the fairness they are entitled to expect from you as jurors. Fourth, during this trial, do not make any investigation of this case or inquiry outside of the courtroom on your own. Do not go to any place mentioned in the testimony without an order of the court to do so. You must not consult any books, records, internet, or any other source of information unless I specifically authorize you to do so. Fifth, do not read about the case in the newspapers. Do not listen to radio or television broadcasts about the trial. You must base your verdict solely on what is presented in court and not upon any newspaper, radio, television, or other media account of what may have happened. Each day, you will be required, as I mentioned, to sign an affirmation that you will follow this admonition of the court. That concludes the court's first instructions then, and as I mentioned, we will be providing copies of those when we deliberate for further reference. Next, at this time then, I am going to have the clerk read the amended and redacted indictment to you. Madam Clerk, if you're ready to read the amended indictment, please do that at this time.
District Court of the 7th Judicial District of the State of Idaho and for the County of Fremont. State of Idaho plaintiff versus Chad Daybell defendant, case number CR 22211623, amended indictment. Chad Daybell is accused by the grand jury of Fremont County of this indictment as follows. Count 1, conspiracy to commit first-degree murder and grand theft by deception. The defendants, Chad Daybell and or Lori Noreen Ballo and or Alex Cox, deceased, and or other co-conspirators, both known and unknown, on or between the dates of October 26, 2018, and continuing until January 15, 2020, in the County of Madison, State of Idaho, and elsewhere, including Fremont County, Idaho, and as part of a continuing criminal transaction and common scheme or plan in Madison and Fremont Counties, Idaho, did willfully and knowingly combine, conspire, confederate, and agree to commit murder in the first degree of Tylee Ryan and to commit grand theft by deception. Count 2, first-degree murder. The defendant, Chad Daybell, on or between the 8th and 9th day of September 2019 in the County of Madison, State of Idaho, and as part of a common scheme or plan for continuing criminal transactions in Madison and Fremont counties in Idaho, were concerned in the commission of a first-degree murder and did aid and abet in its commission, or not being present, advised and encouraged its commission, or by command compelled another to commit the crime, and did so with malice aforethought, and did so willfully, deliberately, and with premeditation, which resulted in the death of a human being, to wit, either kill Tylee Ryan and or assist in the killing of Tylee Ryan, and or did encourage the killing of Tylee Ryan, and or did command another to kill Tylee Ryan in violation of Idaho. Count 3, conspiracy to commit first-degree murder and grand theft by deception. The defendants, Chad Daybell and or Lori Noreen Ballo and or Alex Cox, deceased, and or other co-conspirators, both known and unknown, on or between the dates of October 26, 2018, and continuing until January 15, 2020, excuse me, in the County of Madison, State of Idaho, and elsewhere, including Fremont County, Idaho, and as part of a continuing criminal transaction and common scheme or plan in Madison and Fremont counties, Idaho, did willfully and knowingly combine, conspire, confederate, and agree to commit murder in the first degree of Joshua Jackson Ballo, hereinafter J.J. Ballo, and to commit grand theft by deception. Count 4, first-degree murder. The defendant, Chad Daybell, on or between the 8th and 9th day of September 2019 in the County of Madison, State of Idaho, and as part of a common scheme or plan for continuing criminal transactions between Madison and Fremont counties in Idaho, were concerned in the commission of a first-degree murder and did aid and abet in its commission, or not being present, advised and encouraged its commission, or by command compelled another to commit the crime, and did so with malice aforethought, and did so willfully, deliberately, and with premeditation, which resulted in the death of a human being. To wit, did either kill J.J. Vallow and or assist in the killing of J.J. Vallow, and or did encourage the killing of J.J. Vallow, and or did command another to kill J.J. Vallow in violation of Idaho Code. Count 5, conspiracy to commit first-degree murder. The defendants, Chad Guy Daybell and or Lori Noreen Vallow and or Alex Cox, deceased, and or other co-conspirators, both known and unknown, on or between the dates of October 26, 2018, and continuing until January 15, 2020, in the county of Fremont, state of Idaho, and elsewhere, including Madison County, Idaho, and as part of a continuing criminal transaction in common scheme or plan in Fremont and Madison counties, Idaho, did willfully and knowingly combine, conspire, confederate, and agree to commit murder in the first degree of Tammy Daybell, and did combine or conspire to commit murder, and one or more of such persons did enact to effect the object, combination, or conspiracy. Count 6, first-degree murder. The defendant, Chad Guy Daybell, on October 18 to 19, 2019, in the county of Fremont, state of Idaho, was concerned in the commission of first-degree murder and did aid and abet in its commission, or not being present, advised and encouraged its commission, or by command compelled another to commit the crime, and did so with malice aforethought, and did so willfully, deliberately, and with premeditation, which resulted in the death of a human being. To wit, did either kill Tammy Daybell, and or assist in the killing of Tammy Daybell, and or did encourage the killing of Tammy Daybell, and or did command another to kill Tammy Daybell in violation of Idaho Code. Count 7, insurance fraud. The defendant, Chad Guy Daybell, on or about October 19, 2019 through October 30, 2019, in the county of Madison, state of Idaho, did with the intent to defraud or deceive an insurer for the purpose of obtaining any money or benefit, insurer or other person, a statement as part of or in support of a claim for payment or benefit, knowing that such statement contained false, incomplete, or misleading information concerning any fact or thing material to such claim, to wit, did present and or cause to be presented an insurance beneficiary form to Life Map Assurance Company in violation of Idaho Code. Count 9, insurance fraud. That the defendant, Chad Guy Daybell, on or about October 19, 2019 through October 31, 2019, in the county of Madison, state of Idaho, did with the intent to defraud or deceive an insurer for the purpose of obtaining any money or benefit, insurer or other person, a statement as part of or in support of a claim for payment or benefit, knowing that such statement contained false, incomplete, or misleading information concerning any fact or material thing to such claim, to wit, did present and or cause to be presented an insurance beneficiary form to Primerica Life Insurance Company in violation of Idaho Code. Signed as a true bill on the 24th day of May, 2021, and signed by the deputy presiding grand juror, acting as presiding grand juror in Fremont County, state of Idaho. And to these charges, the defendant has entered a plea of not guilty.
All right, thank you very much, Madam Clerk, for reading the redacted amended indictment. In this case, again, I will advise the jurors, remember the indictment is a description of charges. It is not evidence. That concludes the court's opening instructions and the reading of the indictment. The jury's been sworn as well. The next matter we would take up then are opening statements. We inquire of the state, is the state ready to proceed with openings?
Yes, Your Honor.
Who will be giving the opening statement?
I will remember.
Very well. Mr. Wood, you may present your opening.
Your Honor, may I inquire, is there a hand mic so that I may address the jury?
I think we do have one. Might take us a moment to get it over to you.
And then I do have a PowerPoint attached.
All right.
May I proceed your phone? Yes, it's for the HDMI. May I proceed, Your Honor?
Yes, you.
Two dead children buried in the defendant Chad Daybell's backyard in September of 2019. The next month, his wife is found dead in their marital bed. 17 days after the death of his wife, Tammy Daybell, this defendant is photographed laughing and dancing on a beach in Hawaii at his wedding. It's Lori Vallow, a woman who was his mistress and the mother of the children buried in the graves on his property. 3 dead bodies. This defendant believed he had a right beyond the ordinary. When he had a chance at what he considered his rightful destiny, he made sure that no person or no law would stand in his way. His desire for sex, money, and power led him to pursue those ambitions. And this pursuit led to the deaths of his wife and Lori's 2 innocent children. Chad Daybell is an author who wrote books about the apocalypse. During this trial, you will hear a story more troubling. And the story is real. Chapter 1. The defendant was a seemingly ordinary man. You'll see that he craved significance. He worked in journalism and he worked as a sexton in a graveyard. He married his wife Tammy in 1990 after meeting at Brigham Young University, and they settled in Utah. As a full-time homemaker and mother, Tammy's love for her family was boundless. Together, Tammy and the defendant started a small publishing company, which Tammy supported in many ways. They had 5 children together. They moved to Idaho, where Tammy became a beloved school librarian. She was devoted to service, her community, and her faith. But for this defendant, that ordinary existence was not enough. Chapter 2. Lori Vallow was a homemaker from Arizona. Your Honor, this mic just.
Sorry, Mr. Lee. Let's see if we get a replacement mic.
I think I got it working now.
Okay.
I noticed that the PowerPoint is not up.
Yeah, look, I think your mic's off. Yeah,
Okay, I didn't turn it off this time, so
you might have a bad battery. You want to from the screen as well.
Your Honor, it's up on the screen and it's plugged in the HDMI. I'm not sure why it's not. Transfer. I don't know if there's any one person who can get that.
Let's see if we can get some help to maybe see if we can get the signal to work on that.
Sorry. Can I proceed?
Yeah, but I'm still not sure on the mic. Is that not working?
Check. Okay, thanks. Apologies for the interruption, ladies and gentlemen. Chapter 2. Lori Vallow was a homemaker from Arizona. She was married to her fourth husband, Charles Vallow, and she was the mother to Tylee Ryan and JJ Vallow. Tylee was a normal, vibrant teenage girl. She loved her friends. You'll hear that she loved her Jeep. She loved Chipotle. She loved her little brother, JJ. JJ was a 7-year-old boy on the autism spectrum. He required extensive special care needs. He loved his sister. You'll hear about a pivotal date that set in motion the deaths of Tammy, Tylee, and JJ. October 26, 2018. That was the day when Chad Daybell and Lori Vallow met at a religious conference in St. George, Utah, where they were introduced by a mutual acquaintance. At this time, both still married to other spouses. That introduction set in motion the reality you're going to hear about. We know what happened next through the defendant's own words. You'll hear. Though both married, Chad and Lori began to have an affair. You will hear excerpts from the defendant's extended text messages to Lori that reveal his mindset and his motivations. In his thirst for sex, power, and money, Chad created an alternate reality where they called themselves James and Elena, names that Chad claimed were from past lives they had lived together. The defendant's text messages reveal their story of lust and their plan for a future together. Chad Daybell wrote that upon meeting Lori Vallow, he experienced a happiness unmatched by anything else in his 50 years. He was captivated by her appearance, so much so, he said she was out of his league. You will hear evidence in his own words, how he was taken by her beauty and spoke about their sexual encounters on many occasions. More than anything else, Chad's obsession with Lori was rooted in her adoration for him. She was the mirror reflecting the grandeur he saw in himself. He called her an exalted goddess. He told her in writing that she had returned to earth to perform a special mission. And part of that mission included being with him. They soon came together and turned their dreams into a plan for the future. One free from what they called obstacles. And those obstacles were Tylee, JJ, and Tammy. Chapter 3. You'll hear that in the world that Chad and Lori planned for themselves, they identified those who stood in the way of their dream as dark. Their spouses, Lori's own children, and any who opposed them were labeled sometimes as dark spirits or even zombies. This was more than an alleged belief of right-wing labor. The evidence will show that it was a convenient narrative that dehumanized people who stood in their way and who were labeled as obstacles. This narrative gave them the pretext to remove people from this world for their own good. Chad and Lori preached that only through spiritual intervention, what they sometimes called casting, sometimes through burning, or even through death, that these dark spirits be cleansed. Enter Alex Cox, Lori's devoted brother. Chad and Lori manipulated Alex with promises of spiritual rewards. They wielded their influence over Alex, drawing him into their plotting and planning of their own future. After the deaths of Tylee, JJ, and Tammy, Chad Daybell gave Alex a blessing. This blessing was reported by Lori, who was present. And in that blessing, he said to Alex, "You have earned the privilege to be a member of their exclusive religious group." And he also said to him, "You have already assisted us in ways that can never be repaid." But you will also see other text messages. Chad and Lori discussed more earthly concerns, that Alex could be the one to implicate them. Alex knew this as well. Shortly before he died, on December 12th, 2019, he told his wife, Zulema Pastenes, who you will hear from, he was afraid he was going to be Chad and Lori's fall guy. Chapter 4. Once their calculated plan was devised, it only took months to execute and remove perceived obstacles in Chad Daybell's path to a new life. Charles Vallow, Lori's husband, who was labeled as dark by the defendant, was shot and killed by Alex Cox in Arizona. Lori stood to gain $1 million, money that could fund Chad and Lori's future. Yet following Charles's death, Lori Vallow awaited a $1 million life insurance payout that never came, only to learn that the beneficiary was no longer her. Upon learning she would not receive that insurance money, Lori would text Chad, "I'll still get the $4,000 a month from SS, meaning Social Security." Chad replied to her in a text that read, "It will be interesting to see if it got changed after he had 2 bullets in his chest." Tylee Ryan, also branded Dark and a zombie, was last seen on September 8, 2019. Subsequent investigations revealed the horrifying truth. Her remains, charred and dismembered, were found in a grave on Chad Daybell's property. Without Charles's $1 million in insurance money to support them, Lori Vallow continued to illegally receive Tylee's Social Security benefits, provided after the death of Tylee's biological father, who had been Lori's 3rd husband. According to this defendant, J.J. Vallow, Lori's son, was also possessed. After he was labeled as a dark entity, his fate was no less tragic than his sister's. His young life was also claimed. Later, his bound body was discovered buried in Chad's backyard, his death by suffocation. Yet while JJ was missing, Lori continued to illegally receive JJ's Social Security benefit, money provided by Charles Vallow's dad. Tammy Daybell, a vivacious, healthy mother, was another individual labeled as a dark spirit to be removed. On October 9th of 2019, she reported being shot at night near her home by a man covered in black. She thought it was a paintball gun. On October 19th, 10 days later, she died in her own home with her husband present. This was soon after an increase in the value of her life insurance to more than $400,000. This defendant rapidly cashed in that life insurance and began looking for condos in Hawaii with Lori. You'll see the rental application he submitted for a couple with no kids. Medical examiners would later determine that the only reasonable explanation for Tammy's death was not of natural causes, but rather a homicide. In fact, you will hear from multiple witnesses that Chad predicted multiple times that Tammy would die in early death. Chapter 5. 17 days after his wife's death, Chad Daybell and Lori Vallow got married and celebrated on a beach in Hawaii, symbolizing what he called their eternal union. Chad and Lori were preparing their wedding well before Tammy's death. Lori was shopping for wedding rings while Tammy was still alive. Now, without the earthly obstacles of spouses and young children, and with Tammy's insurance policy and the children's Social Security funds, they could live the life that Chad and Lori wanted. Nothing was going to stand in their way. Chapter 6. Unfortunately for this defendant, reality soon shattered their bliss. 2 things led law enforcement to his and Lori's door. On October 2nd, 2019, Lori Vallow's nephew-in-law, a man named Brandon Boudreaux, was shot at in Arizona by someone from what he believed was Tylee's Jeep. Law enforcement in Arizona investigating Brandon's shooting contacted law enforcement in Fremont County, Idaho, to look for Alex Cox and for Tylee's Jeep. And you'll hear that that Jeep was later found in Rexburg, Idaho, in Madison County. Meanwhile, J.J. Vallow's grandmother, concerned that she hadn't seen or heard from him in months, asked police for help. The police followed up and located Lori in Rexburg, Idaho, where the police did a welfare check at Lori's apartment. Law enforcement arrived at Lori's door on November 26, 2019. When asked about Lori, Chad first told law enforcement he didn't know her very well, despite the fact that they were married and had been in a relationship for over a year. Lies by Lori to police about JJ and Tylee's whereabouts, and then a move to Hawaii, and Lori's unwillingness to present her children to law enforcement to prove their well-being led to her arrest and extradition. As Lori refused to produce her children, law enforcement continued their search for Tylee and JJ. During that search, they located a unique text message that this defendant, Chad Daybell, had sent to his wife Tammy on September 9, 2019, which was the day after Tylee Bryant's last known appearance. You'll hear from the FBI agent who found that message. But this message seemed longer than his usual text to Tammy, and it had a more conversational tone. In that text, Chad claimed he'd had an interesting morning, that he'd shot a raccoon, that he'd buried it in what they called the pet cemetery, and that he'd had a fire on the property where he burned some wood debris. When law enforcement finally went to the defendant's property the following June, they didn't find a raccoon. They found Tylee's burnt remains that were buried in the pet cemetery. And they found JJ nearby, buried under a tree near a pond. Ladies and gentlemen, you've been told this would be a lengthy trial. You will hear from many witnesses. You will hear a lot of evidence. You're going to hear a lot of dates. The following is just a timeline of major events to help understand when these things took place. October 26, 2018, Chad and Lori meet in St. George, Utah. July 11, 2019, Charles Vallow, Lori's husband, shot and killed by Alex Cox. Between August 31st and September 1st, Lori, Alex Cox, and Tylee and JJ moved to Rexburg, Idaho, just a few miles south of the defendant's home. Tylee's last known sighting was September 8, 2019. The text I just spoke of about the raccoon was sent by the defendant to his wife September 9, 2019. JJ's last known sighting you'll hear about September 22nd. The attempted homicide of Brandon Boudreaux in Arizona was October 2nd. The shooting I mentioned of Tammy, the shooting at her, the unsuccessful shooting, October 9th, 2019. Tammy's death, October 19th, 2019. 17 days later, Chad and Lori marry in Hawaii. Law enforcement did a welfare check looking for JJ November 26, 2019 in Rexburg, Idaho. November 26th and 27th, Chad and Lori leave town. June 9th, 2020, Tylee and JJ's remains are found on Chad's property. As I said, you're going to hear a lot of evidence from a lot of witnesses. And there's going to be kind of different groups of evidence you're going to hear from. You'll hear from law enforcement, some of whom will give you a broad overview of the investigation and what they did, how the search for Tylee and JJ turned to a case of murder. You'll hear how it began by people who knew Lori and Chad. The James and Elena. You'll hear about the James and Elena story and about their relationship with each other and how they pursued their dream, their plan for a life together. You'll hear in the defendant's own words, people referred to as obstacles, how they need to be gotten rid of. You're going to hear financial evidence. You'll hear from an FBI forensic accountant and a detective, a Social Security administrator, investigator, who will talk about the finances involved in this case. You'll hear more from law enforcement, from multiple law enforcement agencies, the Rexford Police, the Fremont County Sheriff's Department, the FBI, Social Security Administration, about the investigation into these crimes. You will see forensic evidence. You'll see DNA testing to identify the body of Tylee. You'll see DNA testing that showed DNA from Tylee was found on at least 2 tools in the defendant's shed. You'll hear digital evidence dealing with geolocation data tied to certain phones that were used in this case. You'll hear from Hawaii law enforcement about searches they performed in Hawaii on the defendant and his wife. Finally, you will hear many of this defendant's own words. You will hear voice recordings of this defendant. You'll hear, recorded phone calls between him and his wife, Daybell. You'll read multiple texts that he and Lori sent back. Another text he sent. Chapter 9, what's unwritten. The defendant stands before you today, charged with multiple crimes. First-degree murder for the death of Tammy Daybell. First-degree murder for the death of Tylee Ryan. First-degree murder for the death of J.J. Vallow. Conspiracy to commit murder of Tammy Daybell. Conspiracy to commit murder and grand theft by deception, the death of Tylee Ryan. Conspiracy to commit murder and grand theft by deception for the death of J.J. Vallow, and insurance fraud. Two dead children buried in this defendant's backyard. The next month, his wife dead in their bed. 17 days later, this defendant marries Lori Vallow. Members of the jury, days or probably weeks from now, when the evidence in this trial is fully unfolded, we will have the opportunity to speak with you again. And at that time, we will ask you to end this horrible narrative. Your verdict will be the link that writes the final chapter of this tragic saga. A chapter that delivers justice for Tammy, justice for JJ, and justice for Tyler. Thank you.
All right, thank you, Mr. Wood. That will conclude the opening statement of the state. Mr. Pryor, a couple of questions. First, is the defense going to give an opening statement now or defer until later? And second, if you are going to give an opening statement, would you prefer we take a mid-morning recess or go forward?
Judge, could we take a short recess? And I have a statement.
Okay, I think this is a good time then for our mid-morning break. We'll go ahead and take that now. And then once that's concluded, Mr. Pryor can give his opening statement to the defense.
All rise.
video.
Take it off.
We have the screen, please. So here at 2 minutes and 6 seconds, this is after Nikolai has stabbed the 4 people that you do see parts of on the video. He's standing next to Ariel. Ariel's there. Nikolai's not by himself. Two minutes, 8 seconds, that's the last you'll see of Nikolai until you see him walking off in this video. You see Dante, or AJ, the boys running back to their tubes, and you see Larian filming in the background. Larian captured what Nikolai was doing at this point, even though this video didn't. And here, in a moment, you can see the edge of Dante's swim trunks on the right. You can see the light on top, the dark on bottom. At this point in Larian's video, Dante's just been stabbed. Next, you see of Nikolai, he's walking off. You can see Dante in the background, holding his stomach, looking down at his wound. Well, actually, you can keep it up for a second, sorry. And then for further context, you see Alex Vang running to Isaac. Let's see Larian's video. Okay, I have the screen. Remember, Nikolai admitted he walked up to he walked up to Dante and stabbed him. He admitted Dante was the last person he stabbed. Here you can see Nikolai, dark swim trunks, bigger build. On the right, you can see Dante, swim trunks, lighter on top, darker on bottom. You'll see Nikolai walk up to Dante and stab him in the chest. You'll see Dante recoil from the stab. You see the boys on the right running to their tubes. And in the second here, you'll see Alex Vang. You'll zoom in on him as he runs to Isaac. I'm going to show that again. So, a few things to note. There's nothing between Nikolai and Larian. He's not surrounded. His friend Ariel is there at this point. There's nothing to the left and behind Nikolai, except his group in the distance that you can't see on video. He walks away from those directions towards a group of people and stabs Dante in the chest, not standing his ground. He's seeking out Dante. That's retribution, not self-defense. And recall too the DNA results. Isaac's DNA and Dante's DNA was the only DNA on the knife. They're also the last two that are stabbed. It makes sense from how the analyst described DNA and how it can wash off. You probably noticed throughout this trial, not a lot of witnesses come off looking great after they testify. There's some exceptions. Obviously, the Good Samaritans who went to aid Isaac and AJ. Eric Von Williams included in that from Nikolai's group. He's the only one who went to their aid. Sheena Lowell, you heard her testify from the Carlson group. You saw her just standing in the background watching what was going on the whole time. She was completely sober. You heard her testify, Nikolai punched Madison. She has zero connection with the group anymore, zero contact. Her and Quentin broke up. Tony is another one. He only comes in to break up what he thinks is a fist fight. He's directing Nikolai towards Nikolai's group. Nikolai turns and stabs him twice. Another one I submit to you is an exception that acted admirably is Isaac. His death was tragic and horrific. This is what you see of Isaac in the video. On the left, he's standing next to his tube, not moving away from his tube. He's pointing at Nikolai to leave. In the middle, when Nikolai turns back to Isaac, Isaac puts his hands up, fingers splayed. The only other thing you see of Isaac is him standing in the background. When the other boys are mocking, calling names to Nikolai, Isaac is just standing in the background. He's not saying anything. He's not doing anything. He's not jeering. He's just standing there holding their tubes. There's been a pretty serious mischaracterization of Isaac's actions with regard to when he gets stabbed. Defense has tried to classify it as a strangulation. Defense accused the state in openings of being selective in the photos we used, the frames, to try to show a certain narrative about Nikolai smiling. As you've seen, he's smiling a lot in the video. But defense is actually doing that when it comes to Isaac. Nikolai never said anything about being choked, never said anything about pain on his neck. Even when specifically asked by the start nurse, never mentions anything. And the video doesn't lie. So on the left, Nikolai has just stabbed Riley, who you heard from multiple witnesses were just standing there. Tony comes to try to break it up. Nikolai stabs him twice. Isaac, just off frame, I submit to you, he just saw Nikolai stab those two people completely unprovoked. Although he was in the background the whole time, not doing anything, he came to their aid. And he pushes Nikolai. You can clearly see it's a push. He has one hand on the arm, other hand on the chest. It's Nikolai's own action of thrusting the knife into Isaac's heart that moves Isaac's hands. You can even see from the release, it's a push. He's not sitting there left holding his hands out in a choking motion. Can we take the screen down?
Yes.
I'm going to show you the video so you can see it's obviously a push. While my computer is loading here, even if it was a strangulation, which it clearly isn't, Isaac was justified in using any level of force. He just saw Nikolai stab two people who posed no threat to Nikolai. Tony was breaking up the fight. He had actually ignored Nikolai at first, walked past him, pushed Dante out of the way. Riley was just standing there. I'm at 2 minutes and 3 seconds. Can we have the screen? Clearly a push. Defense has mischaracterized the entire situation as 13 on 1, implying it's some sort of mob beating up Nikolai. It's not even 13 people yelling at Nikolai. As you saw in the video, Gabby, Janelle, they're just standing in the background. Isaac, he's just standing in the background, not yelling anything. It's 13 people in the proximity, only 2 close to him, 2 tiny females. Nikolai's clearly not afraid of the boys. He ran up on the boys, turns his back on them and others multiple times. Even at worst, this is a 2-on-1 with AJ and Dante. But even then, as you saw in the video, Ariel's right there. It's more like a 2-on-2. Ariel's right there. Plus, Tony comes in as a neutral party to separate things. It's not 13-on-1. As soon as AJ gets disemboweled, you see people start to move away. So there's not even 13 people immediately around. You saw Owen way in the background because he saw the knife. So why try to mischaracterize the situation? Because there's some things that are hard to explain otherwise for defense. Turn on the screen, please. This is the second time you saw in the video that Nikolai turns his back on the boys and people from the Carlson group. You don't turn your back on somebody. It's common sense. You don't check your common sense at the door when you serve as a jury. You don't turn your back on somebody if you're afraid of them, especially if you're so afraid you got to reach for your knife. You can't be that afraid that he's got to reach for his knife and so unafraid that he turns his back on them. He was angry, not afraid. That image on the right is only less than 30 seconds after he turns his back on them, touching his knife. The defense tried to explain that change from in that 30-second window by saying he was getting pushed by Madison and Ryan. He was getting pushed. They're lightly touching his arms and they're tiny. They're not in his face. You can see in the images, they're standing close. They're not in his face. They're not shaking their fists at him. They're not even sticking their fingers in his face. They're standing close to him, touching his shoulders, pointing, yelling at him to leave. I'm going to back up a little bit and talk about Nikolai looking for the phone. So Eric Von Williams from Nikolai's group, you heard testify, before any of this happened, he was concerned about Nikolai's behavior. He was concerned that people were going to think he was a predator. Ernesto told Nikolai not to go look for the phone. Others in the group told him not to. You heard they didn't care about the phone. Ariel didn't care about the phone. Nikolai went. Sandy said he went twice, was back for 5 to 10 minutes, then went again over by the boys. Defense argued in opening that the boys' their goal was to humiliate Nikolai. Clearly, he wasn't looking for little girls. But the boys are not completely unreasonable in their belief. Eric Von Williams thought the same thing. They reacted wrong, but they just didn't invent this whole thing in order to humiliate Nikolai. What about Nikolai? 52 years old, apparently sober, according to, I think, what defense will argue. He didn't have any signs of intoxication when law enforcement made contact with him, but he certainly made a point of telling Lieutenant Hart multiple times how much he was boozing and drinking on the river. He can't let it go that he was insulted. So much so that as the boys are tubing away from him, all Nikolai has to do is stand there. He doesn't even have to take a step back. He just has to stand there, let the boys continue tubing. They're down in their tubes. He starts walking up to them, touches his knife, and then runs up to them. You heard Nikolai's ridiculous description or explanation for why he ran up on the boys. Because one was holding a phone. He thought it was Ariel's phone. You also heard Nikolai had to concede, had to admit that pretty much everyone on the river had those phone cases. Another double standard from defense is physical attributes of those involved. They wanted to elicit evidence that Nikolai is feeble. Sandy, he wasn't feeble according to Sandy. He had a surgery a couple years ago, recovered in a few weeks. Maybe things took him a little longer than they did before. He wasn't feeble according to Ernesto. You heard Ernesto, when he was being asked about the stabbing, said, he's a big guy, he was in the army, he doesn't need a knife to defend himself. He didn't say, oh, he's this fragile old guy. He's clearly not feeble, as you see in the video. He runs up on these boys in the water. He leaves behind devastating, devastating injuries. Slices clean through 2 of Isaac's ribs. He comes out of the whole event essentially uninjured. While defense tries to argue that Nikolai is this feeble old man, they ignore that the only 2 people actually standing close to Nikolai are these 2 females that are barely over 100 pounds. If the boys are a threat, why does Nikolai run up on them? And clearly he knows they're not a threat to him. When he ran up on them, grabbed their tubes, standing over them, they did nothing. They didn't kick up at him, they didn't punch at him, they jumped out of their tubes and moved away from him. He knows they're not a threat to him. They're mocking, saying cruel things, but not violent. You saw how awkward it was for Nikolai to try to explain this transition from 0 fear to 10 out of 10 fear. He's got to take out his knife. Try to explain it with what I submit to you is obviously rehearsed testimony about his scales of fear. You heard from witnesses recounting what they recall of Nikolai, the demonic look on his face, staring through people, smirking. Defense argued an opening, it's a slide 2 or here, there. You know, after seeing the video so many times, that's not the case. When he's not glaring, he's smirking in the video. Recall, I asked Ernesto, his best friend, when he was trying to describe the shock of Nikolai, asked, was he smiling? He didn't say, yeah, he smiles when he's scared. He smiles when he's nervous. He said, who's going to smile in a situation where they're in shock or in fear? Nikolai was angry. He wasn't afraid. He's smirking even as he's holding the knife. Why didn't he just walk away? Defense tried to argue there's rocks unstable, his sandals were bad, didn't stop him from running up to the boys as they're tubing away from him. Why didn't he just hold the knife up? Say, hey, I got a knife, back up. You saw, Owen is the only person who saw the knife and you saw his reaction. So everyone else was moving forward and responded to Nikolai punching Madison. Owen's trying to pull people back. Next you see him, he's off in the distance. This whole thing would have ended if Nikolai just held up the knife. Instead of opening it down by his waist without looking down, because it's human nature, if he would have looked down, people would have looked down. He holds it down by his waist, opens it up, never displays it, or says he has a knife. Nikolai did not act as any reasonable person would in that situation if they were truly in fear of their life or great bodily harm. So let's talk. Here's Owen reacting, as you see. Again, Isaac just standing in the background in the middle. You see when other people are moving forward, Owen's trying to pull them back. You heard him yell, bro, he's got a knife. So let's talk about the punch to Madison. I submit to you the evidence shows clearly, beyond a reasonable doubt, Nikolai punched her. She fell backwards, but caught herself. Multiple witnesses testified to seeing her falling backwards. Defense is saying, arguing on cross, well, she's not wet, she didn't actually fall down. If witnesses are all standing in that kind of semicircle around Nikolai, she gets punched and falls backwards, and then their attention's back to Nikolai as Dante's hitting him. They're not going to see that she caught herself. They're going to think she fell down. Look at her position next to Riley. They're shoulder to shoulder in front of Nikolai before the camera pans away. When the camera pans back, now Dante's shoulder to shoulder with Riley, and Maddie is back. She clearly got knocked backwards. Her sunglasses aren't on her head anymore. Defense has a double standard about that too. If there's not a photo of it, it didn't happen. If there's not a photo of an injury, it didn't happen. We know Nikolai got punched. He didn't have any injury. Defense can't have it both ways. So turn and talk a little bit about memory, credibility. Obviously, a witness's memory is better closer to the event. That's obvious. Alcohol is going to affect memory. Traumatic events going to affect memory. How fast it happens is going to affect memory. But crucially, and absolutely crucially, there's a huge difference between getting some details wrong, right hand, left hand, sequence of events, and making up an entire story like Nikolai did. Defense has tried to highlight throughout the trial, Nikolai was in this traumatic experience, give him a break. It's understandable, he made up all these lies, told this whole story. Even though he looks calm and collected in the videos, he's convincing in the videos, talking to the sheriff, talking to Lieutenant Hart. But don't give any sort of credence to the theory that trauma affects memory for anyone in the Carlson's group, any of the boys, any who were stabbed, any who had to drag Isaac as he's bleeding to death to the shore. AJ, who was disemboweled, don't give any credence that trauma might affect their memory and how accurately they can remember all the details. But Nikolai, who invented an entire story, tried to skip through the crowd. Give him credence for that. You saw what happened to all these witnesses, how fast it happened. It's not surprising, some of the details are wrong. But the major point is accurate, is consistent. This all started when Nikolai punched Madison, whether it was the right hand or left hand. You heard the turmoil of the boys when they realized Isaac is stabbed. Clearly a traumatic experience. There's a big difference between details and invention. Think about the most basic example. You and say your partner go to the grocery store, park your car, you're leaving the grocery store, you think your car's parked over there, they think it's parked over here. You still know the car is parked in the parking lot, even if you can't remember where it's parked. The same is true for the punch to Madison. You heard from 10 people, both from the Carlson group and the Boyce group, that Nikolai struck Madison. So let's talk a little bit about witnesses from Nikolai's group. Ariel, what did he say? At trial, he says Nick defended himself. Can't really say how. Never said that when interviewed with law enforcement. He denied even being close to Nikolai. Remember, Ariel was there when he stabbed Dante. He was right there when Nikolai stabbed Riley, Tony, and Isaac. Law enforcement went there with the frame of Ariel standing next to Nikolai when Nikolai has the bloody knife. Ariel denies seeing anything to law enforcement of what Nikolai did. Ernesto, at trial, testified he didn't see Nikolai get hit, just saw him down in the water. Said he couldn't remember Nikolai saying, "They took my knife." You saw on the body cam, he said that repeatedly. He testified that somebody was walking towards him, he pointed at him, "Get back." Never said that to law enforcement, although he did describe to law enforcement, as you saw, him saying, Nikolai, get out, Nikolai walking out, and then he said, and that's it. Never said anything about anyone pointing at him and walking towards him. When I asked, he said, I wasn't asked that question. But he described that event. He also wasn't asked more than 10 times if Nikolai said they took my knife. So, about the punch to Madison again. Sergio, he's in Nikolai's group. He had walked out a little ways. You can see him in the photo on the left, in the top right. He had the white shirt, white bucket hat. He testified he saw the blonde girl in the black leotard walk over to Nikolai and say, go, go, go. He said it repeatedly to law enforcement. And he said Nikolai pushed her. So this is what it would have looked like from his perspective, although a lot farther back in that photo on the right. How could he have seen Nikolai do anything to Madison unless she got pushed back, punched back, something violent, not some light push? He's not going to see that from where he was. Madison testified, and you saw in the video, after she was hit, she goes back to her group. Why would she walk away back to her group if Nikolai just lightly maybe touched her, maybe didn't? She told Quentin she was punched. She told police at the scene she was punched. She told police in the interview she was punched. She testified about feeling the throbbing pain in her cheek, her heartbeat in her cheek. Maddie testified she was told by law enforcement, sheriff's office, they didn't need the photo. You heard about that misunderstanding. She had anxiety about deleting the photo. In an effort to console her, she was told, don't worry about it. This is an important jury instruction in your jury instructions. Although we're not a stand your ground state, there's also not a duty to retreat. But in determining whether Nikolai's actions, whether his use of force was reasonable to prevent or terminate the interference, you may consider whether he had the opportunity to retreat with safety, whether such retreat was feasible, and whether he knew of the opportunity. He turned his back on them multiple times facing open water. People were yelling at him to leave, to walk away, to go. And he didn't. Instead, he took out his knife. That is not reasonable. You heard from Sheena Lowell, Janelle Duxbury, Ghazi Khazri and Nazimpour, Dante Carlson, and AJ about the strike to Madison. You heard from the boys, Ryan Nelson, Juwan Cockfield, Landon Wire, and Alex Vang. Alex Vang originally described it as a slap. You heard from Owen that he heard an impact and saw Madison fall back and catch herself. Defense has to argue that they're all either lying or mistaken. All these witnesses, including Sergio. If they're lying, why would Quentin say, I saw some swelling and some slight redness, but didn't see the punch? Why wouldn't he just say, yeah, I saw the punch too? Why wouldn't Tony say he saw the punch? Why wouldn't Tony say he saw Riley get stabbed and she's just standing there? They tried to explain what happened as best they could remember. The punch isn't on video, but you see the reaction. You hear Dante yell, you can't hit a woman before Riley is stabbed. They obviously didn't plan this lie in the chaos of the moment. So the only thing defense can argue is they're mistaken. That all of these people standing around Nikolai in that half circle, approximate shape, they're all looking in that direction, including Sergio, including Sheena, who was by the group, the tubes for the crossing group. They all were wrong in what they saw. Another defense double standard, it's relatively minor, but I submit to you it shows that they're grasping at straws, is this trying to put Nikolai's group in a different category. There's the drunks on the Apple River, then there's Nikolai's group. About half you raised your hand that you've been on the Apple River. That's what people do on the Apple River. They go out, they tube, and they drink. Nikolai was in the exact same boat they were in. He wasn't bird watching and this group of drunk teenagers ran up on him. He knew what it's about. He'd been on the river before. Another thing about the punch to Madison, you heard that they didn't get to see the video before giving their statements. Even Jawan, who took the video, said he got far enough to get the screenshot of Nikolai.
From Meridian, Idaho, over here on the west side of the state. I want to talk to you a little bit today, and at my age, video presentations are not something that would come easy to me. So I'm just going to talk to you a little bit about my view of the case and the facts and evidence. And what's important are facts and evidence. I think that when we went through the jury selection process, we talked about facts and we talked about evidence. And the judge gave you an instruction to talk to you a little bit about you take into consideration the facts of this case and not be distracted by other things. Don't be distracted by speculation. Don't be distracted by guesses or assumptions or hunches. It all comes down to facts and evidence. So I'm going to talk to you a little bit about the facts and evidence in this case. Chad Daybell, and I'm learning this, and I've had some time to learn about this because it didn't come natural to me. But Chad Daybell went on what's called a mission early on in his life. And I guess what a mission is, I'm not familiar with that, but I guess what a mission is they go away to a location and they talk to people about their religious beliefs. And Chad's faith, that was important as part of his faith. And when they return from these missions, they start the process of moving on with their lives. And when Chad got back from doing his mission in New Jersey, he met Tammy Daybell. Another fact that I discovered, and you'll hear a little bit about, is that Chad had an extended engagement, had an extended by his faith standards romance before they got married. Chad and Tammy dated for approximately 6 months. And what I understand is by their nature, 6 months is an extended dating process before you end up getting married. So after 6 months, they got married. They were married in Utah and proceeded then to have children. They have 5 children, now all 5 adult children. At some point, they moved back here to Idaho, or moved to Idaho, and they started a small publishing company. And you'll hear testimony that the publishing company was predominantly run by Tammy. Tammy managed it. Tammy was the brains behind the company. And Tammy basically took the reins and did everything that was necessary to move this publishing company. It was a small publishing company, a very small publishing company. And what they did is basically publish books. Chad would write these books. And he would write these books about his religious experiences. In his faith, he had certain beliefs, faith that he practiced. You know, when he went on his mission, when he read his interpretation of the books that he used for his faith, he started writing books about things that were consistent with his faith. Things like premonitions. We've all heard of premonitions, about being able to predict things, about being able to see maybe when things happen. And some people believe in that, some people don't. Some people have personally experienced that, or I've been here before. But he writes about his premonitions. He writes about good and evil, and what it means to be good, and what it means to be evil. He writes about dark and light. He writes about subjects that are a little darker, like death, and maybe the coming of the end of things, and when his Savior in his mind is going to come back, and maybe there'll be some kind of a redemption of some sort. But his books covered a lot of subjects like that, and they were all based on fiction. In other words, he was writing these books about theories and things that came into his head, and he would write these stories. But he also wrote children's books, and he wrote books for teenagers, and he wrote these books about adventures and then some crazy ideas about things that kids and teenagers get involved in. In about October of 2018, Chad was going out, and he was invited by one of the witnesses that you'll hear in this case to speak about his books. And this was not uncommon. He would travel, and he would be asked to say, well, come and talk about some of the things that you believe in. You've talked about these premonitions, some life experiences. You're going to hear testimony about that. And he was invited on one particular occasion in late October. And he attended this, and while he was there trying to sell his books, and like most of us who are business people, the focus of these meetings really was for Chad to try to get his books published, because that's how he made a living. And he was there in one of his booths trying to promote his books, and he laid them out there. And this beautifully stunning woman named Lori Vallow comes up, and she starts giving him a lot of attention. And she pursued him, and she encouraged him. And you'll hear testimony that she went so far as to grab behind the booth and sort of help him in trying to sell some of his books. She obviously had an interest, and maybe she felt that he was this publisher, or maybe she had an opinion. You'll hear testimony about that. And then after the seminar, there was a length of time where there was no contact between the two of them. A month and a half, 2 months. And during that time, Chad Daybell went on his day-to-day life. He'd been married to Tammy for some 29 years, has no remarkable background of any kind. I think the testimony we'll offer will show he had a speeding ticket in 2005. Lori Vallow was a different story. Lori Vallow was someone who, right out of high school, married her first husband. You'll hear testimony about this. That marriage was very short-lived, very short-lived. She then married husband number 2 a few years later. And again, very short-lived marriage. And there's some testimony indication that there were some problems with the marriage that caused the breakup. But the theme seems to be that Lori's brother Alex, and you're going to hear about Alex Cox. Alex Cox was Lori's protector. Alex Cox would do anything and everything to protect, aid, and assist Lori Vallow in whatever her endeavors, without unbridled question. Anything. And if Alex Cox even perceived that there was a problem, Alex Cox reacted. You're going to hear testimony that in 2007, I believe it was in August of 2007, Lori Vallow had finished up going through her third marriage with Joseph Ryan. It was a tumultuous, you'll hear testimony that it was a tumultuous marriage, a terrible marriage. And Lori Vallow made accusations against Joseph Ryan of abusing their child Tylee. Yes, the same Tylee. And during one of the visits of 2007, folks, and I want to tell you, you're going to hear testimony that in 2007, Chad Daybell didn't even know Lori Vallow existed. But Alex Cox After one of the exchanges and the visitations with Tyree, Alex Cox approached Joseph Ryan and shot him with a taser and assaulted him. Was eventually charged with aggravated assault, was eventually put in jail, and had this on his record. And there was representation, the facts will suggest that at the time Joseph Ryan feared for his life. This was a serious situation. But it set the pattern for what we're dealing with Alex Cox. Whenever there was a problem or a threat to Lori Vallow, you'll hear testimony that Alex Cox came to the rescue. But Alex Cox would run without even question and do whatever was necessary to solve Lori Vallow's problems. We're going to fast forward then to 2019. Lori Vallow is still married to Charles Vallow. And the prosecuting attorney mentioned this, yes. Chad Daybell at that point, coming in January and February, started to have communications with Lori Vallow. And yes, folks, it turned into an inappropriate relationship. 2019 and forward. And yes, he was engaging in discussions. He was engaging in contact with her, all of the things that the prosecutor talked about in terms of a relationship. But subsequent to the seriousness of this relationship getting rolling, Alex Cox was at a visitation in 2019 with Charles Vallow. And Lori Vallow was there, Tyree Ryan was there, JJ was there. They were all present. And during that altercation and that supposed visit, much like with Joseph Ryan, Alex Cox took out a gun and shot Charles Vallow. And then after calling 911, he then finished the job and walked up to him at close range, finished him off. Now you're going to hear testimony that in some way Chad Daybell was implicated in that. And you're going to hear further testimony that he was not. You're going to hear testimony and see documentation that suggests that the prosecuting attorney on review of this indicated that there was no likelihood of conviction of Chad Daybell. You'll hear testimony that Chad Daybell had nothing to do with the execution by Alex Cox, Charles Vallow. And the same for Brandon Boudreaux. You will hear that Chad Daybell is not being pursued for any involvement in the Brandon Boudreaux attempted murder. Those occurred and those are separate, as well as the Charles Vallow. So what we have is we have a situation where someone who's 29 years old, Chad Daybell, 29 years of marriage with Tammy Daybell, no discernible issues in his life. And then Lori Vallow comes in the picture, Miss Texas. You'll hear testimony about this beautiful, vivacious woman, very sexual person, and very manipulative. And she knows how to get what she wants. And she drew Chad Daybell into a relationship, and an unfortunate relationship, that Chad fell into. After that, things started rolling, and issues started happening that eventually, yes, there was a murder, and there was a burial. And you've heard discussion about the backyard of Chad Daybell. Well, we have a 4.5 acre farm in Fremont County, Idaho. And you'll hear testimony that the body of J.J. Vallow was discovered behind an irrigation pond and a tree out in the pasture. So technically, yes, maybe the backyard, but more accurately described as the pasture, hidden behind a tree. You're going to hear testimony that also in the middle of this pasture was a raspberry patch, former raspberry patch, that was then turned into a place for them to bury the cats, the dogs, and all of the animals on the farm. Okay? Again, out in the pasture of the field and not the backyard. You'll hear testimony about that. You're going to hear from 4 experts that I'm going to bring forward. And these 4 experts, the first one is going to be Dr. Greg Hampikian. And Dr. Hampikian is a bit of a notable local from Boise State University. And Dr. Hempenkian is a DNA expert, considered one of the best DNA experts. He's been involved and has significant work that he's done on both the defense and for the prosecution. He was involved and led the team with Amanda Knox in Italy that got her exonerated because of the DNA evidence. He has substantial experience. And anybody or anyone who knows anything about DNA goes to Dr. Hempenkian first, because he is the guy. And Dr. Hempenkian is going to talk a little bit about the DNA evidence that's found on the scene. Dr. Hempenkian is going to talk about the fingerprint on the plastic that J.J. Vallow was discovered in, was that of Alex Cox. Dr. Hempenkian is going to talk about the hair sample that was found on the plastic of Alex Cox and that it was Lori Vallow. Dr. Hempenkian is going to talk about several, and I mean several other hairs that were found on the plastic of J.J. Vallow. But he's also going to say that there was no DNA evidence, no hair sample of Chad Daybell, Tylee Ryan, or on J.J. Vallow. You're then going to hear from Dr. Raven. Dr. Raven is a forensic pathologist, and she's going to talk a little bit about the circumstances surrounding Tammy Daybell. And what Dr. Raven is going to say is that there's no indication that this is either a homicide or any other crime, and that the only conclusion she could come to is you can't determine what the cause of death was. There's no way to determine it. Tammy Daybell was buried. You'll hear testimony about that. And then a short time later, the police officers showed up and they dug her body up after she'd been buried, after she was laid to rest, and then continued after the body was pulled out of the ground and continued to examine it for whatever they were looking for. And what you're going to find is based on that, Dr. Raven's going to say you can't determine what the cause of death is. You're going to hear testimony from the Daybell children, from the children themselves. 4 of the 5 children, I think, three or 4 of the 5 children testimony. They're going to talk about their mother's health struggles. They're going to talk about their mother's use of various medicinal treatments that she would use, oils that she would put on her leg, medicine and different herbs that she would take, and that her mother was suffering from, that their mother was suffering from a number of maladies, and that she would refuse to go see a doctor or get it treated. And Dr. Raven's going to enlighten you a little bit about some of the circumstances regarding Tammy Daybell. You're then going to hear from Patrick Eller. He's a forensic digital data examiner. And Patrick Eller is someone who has spent his life in the military working for various agencies, and we'll talk a little bit about that, within the government to do data retrieval and data research. And he's going to talk a little bit about the phone records that are involved in this case. He's going to specifically talk about the travels of Alex Cox, because you are going to hear testimony that Alex Cox went to Chad Daybell's property on the 9th of September. You're going to hear that Alex Cox approached Chad Daybell's property a half a dozen other, 5 or 6 other times. You're going to hear testimony that Alex Cox was there on the 23rd. And you're going to hear where Alex Cox was in a number of other times and places in his whereabouts and his travels for about a 2.5 month period. And Patrick is going to, offer you some information and data to support all of that. And finally, you're going to hear from a forensic anthropologist, and his name's Eric Bartlink. And Mr. Bartlink is going to talk to you a little bit about the nature and the nature of how the remains of Tylee were burned. Eric Bartlink is going to talk to you a little bit about the lack of complete skeletal remains and why, when Tylee was dug down in the ground, there was not a complete set of skeletal remains. In fact, there were a number of pieces of that were missing. You're going to hear a lot of evidence, and the judge has talked to us a little bit about not making a decision until we hear all of the evidence. And there's a specific jury instruction that talks about that. The jury instruction is, consider all the evidence. Listen to the instructions from the court on how you're to proceed. Listen to the arguments of the prosecuting attorney and the defense, and then and only then do you make your decision. And at the conclusion of all that evidence, and at the conclusion of the judge's instructions, the arguments of both of the defense attorneys, I'm going to ask you folks to return a verdict not guilty. Thank you, folks. Thank you for your time. Thank you.
All right, that concludes the opening statement of the defense then. This time we will commence with presenting evidence. I understand the state does have a first witness to call. Is the state ready and prepared to do that?
Your Honor, the state is prepared. We had spoken with your clerk earlier. We thought we were going to have a brief sidebar.
Oh, let's discuss our schedule and put there in sidebar. Sure. Council, thanks for discussing scheduling. Our intention here will be to start with a state's first witness that apparently will take some time. So we will plan on taking a lunch hour also at right around noon if possible. So Mr. Wood, are you going to be calling the first witness?
Yes, Your Honor, and the state will be calling Ray Hermesian.
All right, well, Call your witness, we'll have him come up and sworn.
Sir, before speaking. When you're facing Madam Clerk, raise your right hand and be sworn.
solemnly swear or affirm the testimony you're about to give will be the truth, the truth, and nothing but the truth, so help you God.
All right. Officer, as you testify, just remember to make a audible response to anything being questioned, so that the record stays clear, and try to avoid speaking over the top of anyone questioning you. That in mind, then, Mr. Wood, if you'd like to inquire, you may.
Thank you, Your Honor. Officer, will you state your name and spell your last name for the record?
Ray Hermosillo, Hermosillo. Is that on?
Your Honor, is that microphone on?
I'm not sure. Yeah. Yeah, why don't you go ahead and start over and just talk right into the mic, please.
Detective, will you state your name and spell your last name for the record?
Ray Hermosillo, Hermosillo.
Thank you. Detective Hermosillo, what is your occupation?
I'm currently a lieutenant in the detective division for the Rexburg Police Department.
How long have you been a detective?
5 years.
And how long were you involved in law enforcement before you became a detective?
Before I was a detective, 18 years.
Have you worked for any other law enforcement agency other than the Rexburg Police?
No,
And are you post-certified?
I am.
Detective, have you been involved in the case regarding Chad Daybell?
Yes, I have.
You know what Chad Daybell looks like?
I do.
Is he present in this courtroom?
He is. He's at the defendant's table for sure. A low screen time.
Thank you. Detective, let's talk about how did you initially become involved in the investigation regarding Mr. Daybell?
On November 1st, 2019, I was contacted by Fremont County Sheriff's Office. I was told that there was possibly a Jeep that was involved in an attempted homicide in our jurisdiction. So at that time, with that information, I contacted Gilbert Police and asked what they needed us to do to assist them.
What did you do?
Gilbert Police asked us to seize the Jeep if it was located. They gave us the address of 565 Pioneer, which is Rock Creek Townhomes. They also asked us,
Detective, I'm gonna stop real quick. Where is that address located? What city?
Rexburg,
What county is Rexburg in?
Madison County.
So once you received that address, what did you do?
Gilbert asked us to seize the Jeep if we had located the Jeep. They also asked us to perform intermittent surveillance. So at that time, that's exactly what we did.
When you say intermittent surveillance, what did you do to perform that surveillance?
When we were driving around, when there was no more calls coming in, we would park in front of the residence, behind the residence, take photographs of anybody leaving or coming in. That's basically what we did for the surveillance.
And do you recall what dates you did that surveillance?
The dates were between November 1st and November 4th when I located the Jeep at 565 Pioneer.
Did you ever see the defendant at that address?
I did. There were a few times during the intermittent surveillance that we had taken photographs of the defendant, Mr. Daybell, and Lori Vallow, either coming or going from the residence.
And that was between the dates of November 1st and November 4th.
Judge, could we have, for the record, have this officer established?
I'm sorry, 2019.
So. And did you, when you talked about seeing Mr. Daybell, was that between those dates of November 1st and November 4th, 2019?
That's correct.
And your primary job was to look for a Jeep, is that accurate?
Yes, that's correct.
Your Honor, I'm going to ask that the witness be handed what's been marked, the State's Exhibit 90. Very well. The court has a courtesy copy and counsel as well.
Mr. Wood, to be clear, it sounded like you said 90, this is 9A.
I believe it's 90. Double check.
I just see the exhibit, so I can confirm my words. It's okay.
You're correct, Your Honor, 9A.
Thank you.
And that would be exhibits 9A through 90. Detective, do you recognize State's Exhibits 9A through 9B?
Yes, I do.
What do they purport to be?
That is the Jeep that I had seized, parked in the parking lot just outside of 565 Pioneer.
And were these pictures taken at the location of 565 Pioneer?
No, these photographs are taken at our impound lot at the police department.
Did you take these pictures?
I did not.
But do you recognize these images as true and accurate representations of the Jeep you seized from 565 Pioneer Drive?
Yes.
Your Honor, I'd ask the State's Exhibits 9A through D be entered into evidence.
The objection from the defense.
Judge, I'd like to move on to your immediate action on the foundation.
All right, you can order or ask foundational questions, Mr. Pryor.
Officer Hermosillo, thank you. You mentioned that you were doing surveillance on the Jeep, is that correct?
That's correct.
Did you have an occasion to get close to the Jeep during that surveillance?
We hadn't located the Jeep during that surveillance. I located the Jeep on November 4th, 2019, and that's when I had it impounded.
Okay, and at the time of being impounded, did you have the occasion to go through the Jeep and observe the Jeep enter? Or were you relying just on the photographs taken in the Jeep? Do you understand my question?
No, sir. You
I'll
repeat it.
rephrase that. Did you have a personal occasion to go through the inside of that Jeep and observe the contents within the Jeep?
Your Honor, I think that goes beyond the scope of this specific exhibit.
I guess the issue, Mr. Wood, is he indicated he did not take these photographs, and some of the exhibits also contain photographs of the interior of the Jeep, so it's proper, more dire negative an objection.
Thank you.
May I continue, Judge?
Yes.
Officer, all I'm trying to establish is I don't want you to be able to testify that, someone else took the pictures and this is what they found. I want you to be able, you're authenticating and you're under oath to swear that these are accurate photos. I'm trying to find out if that knowledge is based on your personal experience, or is it simply based on the fact that you're relying on somebody else who told you this is what we found? So that's what I'd like you to clarify for me, if you would, sir.
Sure. I impounded the Jeep. I was standing next to the officer taking the photographs, and I also went through the Jeep personally.
Okay, I withdraw the objection. Thank you, officer.
All right, exhibits 9A through D are admitted.
Thank you. May I publish to the jury?
You may want to have a quick sidebar with counsel.
About the reporter?
All right, Mr. Wood, if you'd like to proceed with publishing the court's instructions there on the sidebar, then you may publish any or all of the photos.
Thank you, Your Honor, and if I could have access to the album. Detective, is this what you saw in State's Exhibit A?
Yes,
Is this the Jeep that you had been assigned to do surveillance for?
that's right.
Did you ever learn who this Jeep belonged to?
I did.
Who did it belong to?
It was registered to Charles Vallow, but we later determined that Tylee Ryan drove that Jeep.
Detective, this is State's Exhibit 9B. Is this that same Jeep?
Yes,
That's all I'm going to publish now. All right, thank you. Detective, while you were doing your surveillance, you testified that you had occasion to see the defendant, Lori Vallow. Did you ever see children with her?
no, we didn't.
Did you ever see anybody else with them?
No.
That's good. Were you, at that time, were you aware of who J.J. Vallow was?
No,
Were you aware of who Tyree Ryan was?
no,
So when you spoke with, is it fair to say that when you were initially contacted by another law enforcement agency, they did not ask you to look for those children at that time?
that's correct.
Detective, did your role in this investigation change after that?
It did.
When did that happen?
After I had seized the Jeep November 4th, 2019, I contacted Gilbert Police and let them know I had the Jeep. Gilbert Police Department flew to Rexburg with a few of their detectives and a few of their crime analysts to go through the Jeep and serve a warrant with the Jeep. They were looking for the infotainment center, which is the middle of the Jeep console. It has the GPS locations, things of that nature, and they wanted the information extracted. So when they were up here on November 18th, 2019, they asked me and the other detectives if during our intermittent surveillance, if we had seen any children. And we told them we hadn't. They stated that that JJ's grandmother.
Judge, I'm going to object. I'm trying to be somewhat open-minded about foundation, but I'm going to object.
I'll ask a question, Your Honor. Go ahead, please. So you did have further contact with law enforcement from Arizona, correct? And which law enforcement agency was that?
Gilbert Police Department.
And was it Gilbert Police Department that was looking for that Jeep?
Yes, it was.
When you followed up with them about the Jeep, did they give you any other information about their case?
They did.
Did any of that information regard children?
Yes, it did.
What were you told by Gilbert Police?
Judge, objection, hearsay.
Coming in for the effect on the listener, Your Honor.
Judge, could we approach?
No, give me a moment to make a ruling on that. I'll instruct the witness can answer the question, but for only the purpose of effect on the listener, if you can clarify that with your witness, Mr. Wood. Sure. And any objections overruled.
Detective, based on your conversation with Gilbert Police, did you take any action regarding any children involved in this case?
Yes, we did.
And for the purpose of what you did, what information were you given that you needed to look up on?
We were informed through their investigation that JJ Bellow's grandmother was concerned for his safety.
Judge, and again, I'm gonna object at this point to renew my objection. That's going beyond.
I'll also stand as bringing up her statements to what.
Okay. Based on your conversation with Gilbert Police, what was the next step you took in your investigation?
We were requested to do a welfare check on JJ Bellow from the Gilbert Police Department.
Detective, had you ever met JJ Bellow?
No,
Have you provided any identifying information as to his age or where he might be?
we were provided very little information, just a brief description of what he looked like, his age, and where he should be, which was 565. Sorry, 565 Pioneer Road, where he lived with his mother, Lori Bell.
Your Honor, I'm going to ask that the witness be handed State's Exhibit 1.
Judge, I'm gonna stipulate to the admission of State's Exhibit 1.
All right, it's being offered, Mr. Wood.
Yes, Your Honor.
State's Exhibit 1 has been offered without objection. The court will admit State's Exhibit 1.
And Your Honor, with that stipulation, I'd actually ask that the witness be handed State's Exhibit 2 and State's Exhibit 3 as well.
Further stipulate to State's Exhibit 2, and stipulate to State's Exhibit 3.
Very well. Then presuming they're being offered, State's Exhibits 2 and 3 are also admitted. And Mr. Wood, if they're going to be published, again, the same issue we discussed before today's.
That's all I'm doing that. Thank you. Detective, can you look at State's Exhibit 1?
Okay.
What is State's Exhibit 1?
That is a birth certificate out of the state of Louisiana.
Your Honor, where this is admitted, may I publish?
Yeah.
Detective, can you identify who this is a birth certificate for?
The name on my birth certificate is Keenan Todd Trahan,
What is the birth date?
May 25th, 2012.
And where is the place of birth?
Lake Charles, Louisiana.
Your Honor, if I may publish State's Exhibit 2.
Yeah.
Detective, I'm going to ask you to turn to the second page of State's Exhibit 2. Detective, what is State's Exhibit 2?
It's a decree of adoption.
And reading through that, are you aware of who that is a decree of adoption for?
Yes,
Who is it for?
Keenan Todd Trahan.
And on the bottom of that, can you read the second to the bottom paragraph? That exhibit.
The entire paragraph.
Yes, please.
It is further ordered, the judge and decreed that the name of the child, Canaan Todd Trahan, be changed as follows. Joshua Jackson Vallow, and the registrar of the Louisiana Department of Public Health and Statistics is hereby ordered to make the appropriate changes in its records.
May I publish States Exhibit 3 now?
Yes.
What is States Exhibit 3?
That is also a birth certificate from the state of Louisiana.
And who is the birth certificate for?
Joshua Jackson Vallow.
Second, in the course of your investigation. In the course of your investigation, have you learned what Joshua Jackson or JJ Vallow looked like?
Yes.
Have you seen pictures of him?
Yes, I have.
Were you able to access pictures of him from iCloud accounts associated with his mother?
Yes.
Your Honor, I ask that the witness be handed States Exhibit 4.
All right, the witness is handed States Exhibit 4.
Detective, you testified that you never met JJ Vallow, correct?
Correct.
How did you come to know what he looked like?
Through photographs we were given.
Where did you get those photographs?
We received a few from Gilbert Police. His grandmother, Kay Woodcock. That's all I can remember.
And I spoke with you briefly before. Did you ever have occasion to review iCloud accounts belonging to Lori Vallow?
Yes, we did.
And on those iCloud accounts, did you find other pictures of JJ Vallow?
Yes, we did.
And did you find videos of JJ Vallow?
Yes.
Based on your investigation, what does Exhibit 4 purport to be?
Photograph of JJ Vallow.
And you didn't take this picture, correct?
Correct.
But you recognize that individual as Joshua or JJ Vallow?
Yes.
Your Honor, for demonstrative purposes, the state would move to admit States Exhibit 4.
Any objection? Judge, there's a little bit of foundation that I want to iron on. No, so what's the source of that picture? Where did
Lori's iCloud, Lori for Style, iCloud.com.
Judge, can we approach just briefly on this issue?
Based on our sidebar with counsel, I understand the defense does not have an objection at this point to exhibit 4 being submitted. Is that correct, Mr. Pryor?
Yes, Your Honor.
All right, exhibit 4 then is submitted.
Your Honor, may I publish to the jury?
You know,
Detective, who is that?
That's JJ Vallow.
Detective, you were talking about receiving a request to do a welfare check, correct?
That's correct.
When did you receive that request?
On November 25th, 2019, in late evening hours, I received a call from Detective Pillar with the Gilbert Police Department, and he requested that
Judge, I'm going to object at this point.
The request isn't hearsay.
at this point, I don't hear an objection on hearsay, so you see.
I repeat the question.
What did you do in response to that request?
On November 25th, 2019, I received a call from Detective Pillar, of the Gilbert Police Department. He requested that I do a welfare check on JJ Vallow the next morning because he wasn't able to get a hold of JJ or
I'll be sustained as hearsay.
Did you do a welfare check for JJ Vallow?
we did.
What date did you do that?
November 26th, 2019.
How did you go about doing that?
On that morning of November 26th, 2019, myself and Detective Daybell went to Lori Vallow's residence where we presumed JJ was at. She lived at 565 Pioneer, apartment 175. As we approached, expecting to speak with Lori, we noticed the defendant, Chad Daybell, and Alex Cox unloading a pickup truck near the garage area.
And at this point, were you aware of who Chad Daybell was?
Yes,
How would you learn about him?
through our investigation with Gilbert and communicating with Gilbert Police Department.
And so you recognized who he was.
Correct.
And at that time, were you aware who Alex Cox was?
Yes, we were.
So after you saw them, what did you do next?
I got out of my vehicle and made contact with Alex. He was standing at the driver's side of his pickup truck, and the defendant Daybell was on the passenger side. I asked Alex if Lori Vallow was home, and he stated that she wasn't home. I asked Alex if JJ was home, that we were there to do a welfare check. And at that point, Alex got a surprised, frightened look on his face, looked over at across the pickup at the defendant Daybell. The defendant Daybell then looked back at Alex. And initially, neither one of them answered my question.
After they didn't answer your question, what did you do?
I asked them again if JJ was home, and Alex Cox finally answered and stated that JJ was with his grandmother in Louisiana.
When you were given that information, did it cause you any concern?
It did, because I informed Alex that it was highly unlikely because his grandmother.
Judge, I'm going to object at this point. We're going to be getting into hearsay.
I'll sustain that.
Your Honor, I think the defendant's about to testify what he said to Alex Cox.
Okay, that's not what I understood where it was going. You can ask the question, Mr. Wood.
Detective, what did you say to Alex Cox?
I informed Alex that it was unlikely because Kay.
Judge, I'm going to object. This is going to lead into hearsay.
Your Honor, this is a statement by a declarant on the witness seat. It cannot be hearsay.
overruled, and it is, permissible, so objection overruled.
What did you say to Alex Cox?
I informed Alex that it was unlikely that JJ was with his grandmother Kay because she was the one who called in the welfare check.
And what was the response to that?
There was no response initially. Alex again looked over at the defendant Daybell, and they kind of both just looked at each other. And at that point, I asked Alex where I could find Lori Bell.
And did he give you a location to find her?
He stated that she was in apartment 107, which is the same apartment complex, just a few apartments down.
What did you do at that point?
At that point, I asked Alex if there was a way I could contact Lori and asked Alex for her cell phone number. And Alex told me that he didn't have her cell phone number.
Were you aware at that point that Alex Cox and Lori Vallow were siblings?
Yes, through our investigation with Gilbert, we knew that Alex Cox and Lori Vallow were extremely close. So when Alex told me he didn't have his sister's cell phone number, I assumed he was lying to me.
What did you do once you received that information?
Myself and Detective Hope left the defendant Daybell and Alex at the pickup truck. We went over to apartment 107 to see if we can make contact with Lori. At that point, we were just trying to find JJ Vallow.
And were you able to locate him at apartment 107?
No, we knocked on apartment 107, there was no answer. So at that point, Detective Hope began knocking on neighbors' doors, see if we can get a hold of anybody who would know if they saw a little boy coming in and out of that apartment or who resided in that apartment. And while Detective Hope was doing that, I started walking back to my vehicle to call for more detectives to come over to our location.
Why did you call for more detectives?
Because of the deception from Alex, I wanted to figure out what exactly was going on. And we were going to start canvassing the area and knocking on doors, so the more detectives we had on scene, the better it was for us.
Detective, to clarify, when you first saw Alex and Chad Daybell, did you speak with Chad Daybell?
No, I personally did not.
So I believe you testified that you started walking back to the original apartment.
Correct.
What happened then?
As I was approaching my car that was parked in the alleyway, I noticed the defendant Daybell driving towards me in a black Chevy Equinox. It appeared he had just left apartment 175 and was headed towards me in the alleyway. So at that point, I stopped him to have a conversation.
What did you ask him?
I asked the defendant Daybell, when's the last time you saw JJ Vallow? And he stated it was in October in apartment 107 with Lori Bell.
Did you ask him anything else?
I did. I asked him how he knew Lori, and he stated he had only met her a couple of times, and that he didn't know her very well.
Did that response cause any concern for you?
It did.
Why?
Through our investigation, prior to me making any contact with the defendant Daybell or Alex Cox, we knew that Chad and Lori had been married 2 weeks prior to my conversation with them in the alley.
So is it fair to say you were troubled by his gentleman? What happened after that?
I asked Mr. Daybell, the defendant Daybell, if he had Lori Ballow's telephone number so I could get hold of her. And he stated he didn't have her phone number.
Did you have any further conversation?
I did. When I was speaking with the defendant, Daybell, Detective Hope saw me talking with him and started to walk back to my location. As he approached, I again asked the defendant Daybell for Lori's number because I assumed he was lying to me based on what I knew. And at that time, he did give me Lori's phone number.
Did he tell you why he didn't give it to you in the first place?
He did. He stated that he felt I was accusing him of something.
And had you accused him of anything?
No, I simply asked him the whereabouts of JJ and asked him for his wife's telephone number.
Detective, during this interaction, were you wearing a body cam?
No, I wasn't.
Why not?
In the detective division, most of our interviews are in a controlled environment. We call people into the police department. We have an interview room set up with cameras. So most of the time we're conducting our business and our interviews at the police department. It's very rare we're the first officers or detectives on scene. There's one body cam between 7 detectives. Unlike patrol, where a patrolman is assigned a body cam, a detective is not assigned.
What happened after you got that information from the defendant?
I called my lieutenant at the time and told him what was going on. I felt that based on the deception and lies from the defendant, Daybell, who is JJ's stepfather, the lies and the deception from JJ's uncle, who is Alex Cox. I felt there was more going on with the whereabouts of JJ. And so at that time, I wanted to get everybody over there to see if we could figure out what was going on. So I asked my lieutenant to gather some detectives and respond to my location.
And then what happened?
A few minutes later, my lieutenant arrived with Detective Dave Stubbs, who had a body cam at that point. We began knocking on doors. We went back to 175, which is Lori Ballow's apartment, and started knocking on her door. We didn't get any answer.
And I apologize if I missed it. Who was your lieutenant?
Ron Ball.
All right, so after you weren't able to get any answers, what did you do next?
Through our investigation, we learned that Lori Ballow's niece, Melanie Boudreau, it was Melanie Pulowski, Melanie Boudreau at the time, it's now Melanie Pulowski. She lived in apartment 174, which is right next door to Lori. So at that point, we knocked on her apartment as well to see if Lori or JJ was at that apartment.
Did anybody answer?
No, they didn't.
What did you do next?
I was instructed to go back to the police department, go to the prosecutor's office to see if we can obtain a search warrant to search the residence for JJ Ballo, while the other detectives stayed on scene and started knocking on doors in that complex. At that point, our only focus was to find JJ and to figure out what was going on. So we were going to exhaust every means that we could to see if we could do that. And that's why I went to the prosecutor's office to see if I could obtain a search warrant.
And did you obtain a warrant that day?
No.
Why not?
On the way to the prosecutor's office, Detective Hope, with the number that the defendant Daybell provided, called that number. There was no answer, but he left a message. Once we got to the prosecutor's office, Lori Ballo called back, and she was instructed to open the door. There were detectives outside of her door that wanted to speak with her.
And are you aware of if any detectives were able to make contact with her that day?
Yes, they did.
Do you know who that was?
Detective Stubbs and Detective Ball.
And you had mentioned earlier that Detective Stubbs had a body cam on, correct?
Correct.
And do you know if their interaction with Lori Vallow was recorded?
Yes, it was.
Have you watched that video?
Yes, I have.
At that point in your investigation, what did you do?
After
After Detectives Ball and Stubbs had spoken with Lori Vallow, what did you do? What did you do next?
we were informed that JJ was with a family friend.
Judge, I'm going to object to this. How about some foundation?
Sustain that. Detective, did you speak with Detectives Ball and Stubbs about their interaction with Lori that day?
Yes,
Did you speak with them that day?
yes,
Did you watch the body cam of their interaction with Lori Vallow that day?
yes, I did.
So you're aware of what she said to them.
Correct.
Based on what she said to them, what did you do next in your investigation?
We attempted to locate the family friend to see if JJ was with her in Gilbert, Arizona.
And do you know who that family friend was?
Melanie Gibb,
Were you able to contact them?
I was not.
Did you have any interaction with Arizona law enforcement day about contacting Melanie Gibb?
I did. It was starting to get into the later hours of that evening. So I contacted Detective Pillar with Gilbert Police Department. And I had him go to Melanie Gibb's residence to see if JJ was there. Ultimately, we learned he was not there.
About what time did you learn that JJ was not with Melanie Gibb?
Roughly 9 o'clock at night.
And what did you do when you found out that he was not there?
I contacted Lieutenant Wall and let him know. And we agreed to meet at the prosecutor's office that next morning early to obtain search warrants for those apartments.
Okay, and just for clarity of the record, which apartments are you talking about?
Apartment 175, which belonged to Lori Vallow, 174, which belonged to Melanie Boudreaux, and apartment 107, because that's the last time JJ was seen based on the defendant Daybell's statements.
Detective, were you able to obtain those warrants?
Yes, we were.
What did you do? Well, what day did you obtain those warrants?
November 27th, 2019, in the early morning hours.
And on that day, did you execute those warrants?
We did.
Let's talk about that. Where did you search first?
We searched apartment 175 first.
Was there a reason you searched there first?
That was his address that we were given from Gilbert Police Department, and that's where his mother lived.
What did you find in apartment 175?
So initially, when we broke down the door, everything looked ordinary. There were couches, there were papers on the table, there was food in the refrigerator, food in the pantry. We went upstairs, there were beds, pictures. Everything seemed that people lived there. The thing that caught our attention was there were no clothes on the hanger in any of the closets. Zero clothes. Just a bunch of empty hangers hanging there like somebody took the clothes off and left.
Did you locate JJ in that apartment?
No,
Did you see any evidence whatsoever to suggest that he had been living there?
yes, we did. There were a couple things. We located a child's Star Wars suitcase underneath a little crawl space under the stairs. It was mixed in with some, what I can best describe as 72-hour kits, and the kits had like flashlights, flares, water. The suitcase was mixed in with those. We also found an old prescription bottle prescribed to JJ of Risperidone. And there were miscellaneous photographs of JJ in the residence.
And did you see any other evidence of any minor children?
No. Correct. We did. When we first went inside, there were some scooters and a small child's, looked like a small child's bike right on the porch.
Okay. Did you seize anything from the home that day?
We did, I seized the Risperidone and the suitcase.
After you searched apartment 175, what did you do next?
We searched 174, which was Melanie Boudreaux's apartment. Everything appeared normal in there. There were no signs of JJ or anything that he was even there. We also searched apartment 107, and that was completely vacant. There was nothing in apartment 107.
Did you seize anything from apartments 174 or 107?
We seized, in apartment 174, we seized some cash, large amounts of cash that were found in the closet. And the only reason we seized those were for safekeeping, because we had kicked the door in there as well, and it wasn't able to lock, so we took that.
Did you locate any weapons in any of those apartments?
So in apartment 175, when we were searching the garage area, we located several different style weapons, handguns, rifles, various calibers, army knives, a lot of different weapons that were inside the garage.
And why did you seize those?
Again, for safekeeping, that apartment didn't lock. And so we took those so it wouldn't be stolen.
Did you find any evidence that JJ Vallow had been in apartment 174?
No,
Did you find any evidence that JJ Vallow had been in apartment 107? Did you search any other building that day?
we did. In apartment 175, we located a storage unit rental agreement contract. And on that storage unit contract was the name Lori Ryan. It had listed her as the tenant, and it listed the storage unit number as T52, and it gave an address of self-storage on Airport Road in Rexburg. So with that information, we were able to obtain a search warrant for that storage unit as well.
And did you participate in the search of that storage unit?
Yes, I did.
What did you find there?
There were a few bikes, children's bikes. There were boxes of winter clothing, some ice skates. There wasn't a lot in the storage unit. There was a personalized, like a family blanket, a big blanket with family photos that were kind of sewn onto the blanket. Those photos had JJ Vallow, Tylee Ryan, and their sibling Kobe Ryan. There were pictures of Lori Vallow. But other than that, there was nothing else really in the store.
When you performed these searches, were you looking for Tylee Ryan?
No,
So to your knowledge, she hadn't been reported missing.
that's correct.
Your Honor, if I could have a brief that far.
Yes.
Mr. Wood, I understand this would be a good breaking point in this testimony for the lunch hours, is that correct?
Yes, Your Honor.
Okay, we're gonna go ahead and take our lunch recess at this time. Before we do that, again, I will just advise the jurors, please don't discuss the case amongst yourselves or with anyone else over the break. In addition, for those in the courtroom, we will be closing the courtroom, I believe, during the lunch break. So things you have in here will need to go with you. We'll reopen upon the conclusion of the lunch break, and we'll still be under the court's governing order for courtroom conduct when we return. So thank you everyone for complying with that. With that in mind, we'll go and take our lunch recess now.
All rise.
You saw what happens in this case if somebody lies about something that happened on video, because Nikolai got burned by that. He made up complete and total lies. Video showed he wasn't telling the truth. The video happens to not show the punch, but it still corroborates what all those witnesses said.
Do you have sound yet, Glenda? No, still closing statements. Do you have sound? Glenda, Dave, Jennifer, do we have sound yet? Now? Can you hear me? Can you hear me? You can hear me? Huh, okay. Let's try again. Can you hear him now? Can you hear it now? I'm gonna have to kick you guys out. Why isn't it working?
Second degree. Again, the difference in second degree is Nikolai's belief.
Can you hear him now?
You know, I submit to his belief from his own conduct afterwards. He knew it was not justified. If you can't
Can you hear me now?
agree on second
Can you hear me
degree,
now?
consider first degree reckless homicide, first degree reckless endangering safety. Element 1,
Sound?
Nikolai endangered the safety of another human being.
Any
It's
sound?
obvious. Endangered the safety of another by criminally reckless conduct. Jury instructions definitely define criminally reckless conduct, creating a risk of death or great bodily harm. It's unreasonable and substantial. He was aware of the risk. Again, obvious when he's stabbing people. When you talk about reckless conduct, let's say you believe his testimony that he just thought anyone touching him, anyone close to him was attacking him and just stabbing him. That's reckless. That's criminally reckless conduct. That's utter disregard for human life. What other clues are there to utter disregard? He just walks away. He just walks away. He doesn't call 911. He just sits on his tube as other people are helping the victims. And he tubes down the river. Your jury instructions talk about the question, the special question, yes or no. Did he commit these crimes while possessing a dangerous weapon, the pocket knife? There's nothing inherently wrong with carrying a pocket knife. A lot of people carry pocket knives. Totally fine to carry it as a tool, totally fine to carry it for self-defense, totally fine to carry any legal weapon, firearm, knife, if it's used legally. Nikolai did not, he was not justified in self-defense when he attacked these people. So we ask that you answer yes on that question. In the end, what is beyond clear, Nikolai knew, all of his actions, from the minute the stabbings are done, from the second the stabbings are done, he knew it. It's obvious. His actions were horrific. They were senseless. He killed Isaac Schumann, stabbed him directly in the heart, disemboweled AJ, stabbed Tony who's trying to break up a fight, Riley who's just standing there, and then walks up to Dante. That walking up to Dante, stabbing him when he's got clear paths to retreat, that destroys any argument that this was self-defense. He was angry. There's no rational reason Nikolai, his group's over here, would walk this way towards the group of people to stab Dante. Senseless and horrific acts. The state asks you to find Nikolai guilty of all charges. Thank you.
Thank you. We will take a 10-minute recess. We'll be reconvening at 11:05. Please take the jury out.
All right.
They do this to a man who has done nothing, absolutely nothing.
Please be seated. All right, we are back in the presence of the jury with the attorneys and Mr. Mew. Mr. Truffesy.
May it please the court, counsel. So, ladies and gentlemen, in his opening statement, Attorney Nelson said to you, one of the things you're going to have to determine is what happened on July 30th, 2022. Well, what happened on July 30th, 2022 is a group of drunk teenagers led by the ringleader, Juwan Cockfield, saw an opportunity to torment a man who was by himself. They taunted him. They called him names like raper and pedophile and predator. They did this for no legitimate purpose. When they did this, they're yelling and carrying on. It attracted the attention of another group, right? Led by Madison Cohen and Dante Carlson. 6 drunk teenagers quickly turned into 13. 13 against 1. They got in his face. They screamed at him. They called him names. They swore at him. They put their hands on him. And the group of 6, they became brave. The group of 6 became brave to the point that they circle him and start taunting him. They do this to a man who has done nothing, absolutely nothing to them. Then, when that man, Mr. Mew, tries to create some space between him and Madison Cohen, they pounce. They punch him. They push him. They slap him. They hit him again. They choke him from all directions. And Nick Mew acts in self-defense. That's what happened on July 30th, 2022. I just want to give you guys a little bit of an indication as to kind of where I'm going to go. And more importantly, what I think you need to think about when you are back there thinking about the evidence, okay? First is the law. 1, there is no duty to retreat, period. That is the only requirement. In this state, bullies like Madison Cohen don't get to tell us where to go. Bullies like Madison Cohen don't get to get in our face and require that we leave. That's not a requirement here. Keep that in mind. 2, subjective beliefs, okay? When you're listening to or contemplating the evidence and replaying it in your mind, you are to do that and consider the beliefs, not the actions, but the beliefs of Mr. Mew. And when you do that, you are to do that from his perspective. At the time that the events were occurring. So while we have a video, that video is from the perspective of Juwan Cockfield. The video perspective that the jury is required to consider it is as Nick Mew is holding the camera. I'm going to address this a little bit later, but the idea of provocation. Whether or not Nick intentionally caused harm to Madison Cohen. That is something that you should consider when you're considering provocation. And the other main one I want to talk about is what it means, because it's different here, beyond a reasonable doubt. So normally, beyond a reasonable doubt is this hurdle, and the state has to jump that hurdle in order to prove a case. It's a little bit different here, okay? Because in this case, self-defense has been alleged. Remember when you're back there, Nick Mew doesn't have to prove he acted in self-defense. They have to prove beyond a reasonable doubt that he didn't act in self-defense. They have to prove that his beliefs were unreasonable. Okay? So the way that I look at this video, the main video of Juwan Cockfield, we've all seen the 9-second video where he's screaming at Mr. Mew, calling him a raper. I'm not talking about that. I'm talking about the video that you've seen probably more than you want to. But I'm breaking that up into really 3 parts, okay? 0 to 149 is the first part, all right? Before anything actually happens in terms of the attack. And what is in dispute in that first minute and 49 seconds? I think 2 things were raised in the case that were in dispute. And that is, first, whether or not these drunk teens were actually afraid of Mr. Mew, right? I think to a person, they testified, yeah, we were really concerned about Mr. Mew. And you get to use your everyday experiences in life when you decide what to believe. Does that look to you like teenagers who are afraid of that person? Is that what that looks like to you? Does this photo of drunk teenagers taunting him, does that make you believe in your experiences in life that they're afraid of him? Or is this what drunk teenagers who are terrified, is that what they look like? Does that make sense to you? because you heard this. As the numbers rose, as the number of people grew, their fear, it decreased. And you've heard Mr. Anderson say over and over again, all Nick Mew had to do was walk away. Well, you heard from each one of those tubers, those drunk teenagers, we could have passed. When he walked over by Madison Cohen, we could have passed. And you heard Owen Pelican. I didn't want to pass. I wanted to see how this was going to play out. Why? Because Joanne Packfield was recording this entire incident. They wanted to see what was going to happen. They're not afraid. They want to see how this is going to play out. And Joanne Packfield said it best of all. It's for the culture. He wanted to put it on the internet so other people could see. And when you're using your everyday experiences in life, ask yourself this. Do people who are afraid of other people, do they walk up on them? Is that what people do when you're afraid of someone? Or do you try to get away from them? If you're afraid of someone, do you taunt them? Do you call them names? Do you circle around them? Those are questions that you all can answer. Or an alternative hypothesis to them being terrified is, do they do those things because they're drunk teenagers and what they want to do is make a video and put it on the internet? Which one of those two things, based on the evidence that you've seen, which one of those things makes more sense to you? The second thing that I think is in dispute, or was at least raised in the first minute and 49 seconds of that video, is whether or not Nick Mew's looking for little girls. Now, Mr. Anderson gets up here and says, no, he wasn't looking for little girls. But he also says, the boys didn't invent that. No, they pretty much invented that. And why do we, or how do we know that? So that's not on video anywhere, right? They don't mention it. They don't say anything about Nick Mew telling them that, right? Every one of them who speaks to the police provides a statement about what happened. Zero mention to the police that he said he was looking for little girls. This gentleman over here, Investigator Schultz, I think he said that he was a sensitive crimes investigator. He saw some of this stuff come across his desk, and that would have interested him. Investigator did testify. Said he would have mentioned, if any of these kids would have mentioned little girls, I would have taken note of that. So, what's the alternative? Why did they say that? I would submit to you that what kind of person does what these kids did to him, and what would they look like as people if all they did was pick a guy out and start to torment him? What do we think of people who do that? What do we think of people who call grown men rapers and pedophiles and predators for kicks? What do we think of those people? They had to come in and say that. Because if they don't, we know what we think of them. That's the reason they came in, and they said this to you guys under oath. They got on that witness stand and swore to tell the truth, and they told you that he said he was looking for little girls. Well, the cops got up under oath and told you Nah, they never mentioned that to me. What are the odds? What are the odds that that actually happened and nobody mentions it to the police? What are the odds? Two other little points on that. In your everyday experiences in life, would you expect a man that you never met to walk up to you and say, if you ask him, how's your day? What are you doing? Oh, I'm looking for little girls. Would you expect someone to actually do that? Does that make any sense to you? He's with his wife. He has lunch with his wife and his friends. In order to believe what these drunk teenagers are saying, you have to believe that he has lunch with his wife, he's with his friends, they're having a fine time. Ariel loses his phone, and Nick goes, this is my chance. My wife's right over there, but this is my chance to go look for little girls. And I'm going to tell a bunch of drunk teenagers I've never met before, that's what I'm doing. Tell me that makes sense to you. Because you get to judge the credibility of what people have said to you. Okay? But I want to talk about what we know in that first minute and 49 seconds of the video. What do we know? We know, based on the evidence, that Nick's looking for a phone. We know that. Ariel said that. Nick said that. They find Ariel's phone in the river. So we know that. We know that Nick comes up to the teenager's tubes, and we know that Cockfield's looking for a phone, and Cockfield's holding a phone. Joanne Cockfield's holding a phone. We know that Nick Mew walks away from them as he passes them. We know that. We know, right, that the drunk teenagers move toward him and start confronting him. We know that. We also know that Nick sees what he believes to be a reasonable, rational adult. So he heads over there to talk to her. And what we know is you can see his thumb, he's motioning back, trying to explain what happened. And we know that Madison Cohen, who knows nothing about what happened, zero, starts screaming at him to leave. We know that Madison Cohen feels comfortable enough to put her hands on him for the first time and move him because, well, she's queen of the river and she decides where people go. So she's moving him. We know that. We know that Nick is uncomfortable, so he waits for his group to come over because the state can say whatever they want. He's by himself. So we know Nick does that. We know that when Nick waves to his group, so does Madison Cohen. But there's one big difference here. Her group shows up. And they show up in numbers. We know that the group of teens are brave. And as this is going on, they start taunting this man who's done nothing to them. We know that. We know that Riley Madison comes over and now she thinks it's necessary because she's been anointed something in the river and she gets to tell him where to go. So we know that she puts her hands on him. We know that Nick's uncomfortable enough that he waves the group over a second time, trying to get someone to come to his aid. We know that. We know that Madison Cohen pushes him, puts her hands on him, again. He tells her not to touch him, but she does it anyway. We know at that point it's 13 against 1. The other thing that we know, because we heard it, was someone in the group, the brave group of 6, tells Nick Mew, you got 10 seconds. In your everyday experiences in life, when someone tells you that you have 10 seconds, what normally comes after that? If we have children, I'm going to count to 3. You got 10 seconds to do this. Nothing's good is coming after that. It's reasonable in our experiences as adults to take that as a threat, right? And if you think about it, they all blamed. They didn't know it, but the guy holding the bag is Isaac. We know it's not Joanne Cockfield, and everybody else denied it. So who's left? Their buddy Isaac. They all blame, without saying his name. It's like, wasn't me, wasn't me, wasn't me. Well, you're saying it's the one person who isn't here, right? That's what we know. We know everything here I just told you is what we know in the first minute and 49 seconds. And why does that matter? What does...
I can't see the exhibits that I'm doing rebuttals.
And step up and go over to the side.
What does that matter? Why does this matter? Because one of the things you have to consider when you consider self-defense is Nick unlawful interference with his person. And I would submit to you, he does. He told you he did, right? We're gonna see the video one time, promise, broken up into those parts.
What is he on? Whoa! What are you talking about? What the hell are you talking about? What? Get away from us! What? What are you doing? What's going on with your homie? He's on camera. Scripting. He's on 14. Yo, the new iPhone got that good quality. What do you say? Yeah, what the hell? Who is this? Yes. Further culture. Who is that? Further culture. Who is that? Who the hell is this? Bro, it doesn't matter. He said he was looking for a little girl. You're looking for a little girl? Yeah. That's exactly what he said. Weirded us out. I even have that part on camera. Did I? Some young ass kid. What the hell is this guy's problem, bro? you. We trying to have fun. He's gonna claim you. He's gonna claim you. We don't want this one.
The second part of the video that I think is important, and Attorney Anderson's talked a little bit about it, is the 1 second that we don't get to see, right? The 1 second where the state is insinuating and is claiming that Madison Cohen was punched. And where Nick Mew has testified that he raises his arm to get her out of his space. So those are the two possibilities as to what happened in the video that you don't see. And I am, once again, asking that you use your everyday experiences in life when you make this determination, okay? And I understand that people in stressful situations don't get everything perfect. I get that. I'm not holding anybody to this exact standard. But what have we heard in order to prove beyond a reasonable doubt that this happened? Well, you heard A.J. Martin say that he grabbed her by the back of the hair and was slugging her from behind. Okay? No one else says that. You hear Alex Vang say he slapped her with a right hand in the face. Then I say, Mr. Vang, how can that happen? He's got a knife in his hand. And he says, you're right, that can't happen. He punched her. You hear Juwan Cockfield, who's not looking at it, he's holding his camera in another direction, says he threw a hook at her. I saw that. Right? Madison Cohen says, she said on direct examination, he hit me with a left hand to the left side of my face. And it sat there. Then when I asked her questions and I said, can you explain how that's humanly possible? And her response was, you're right. I get lefts and rights wrong. He hit me on the other side. Okay. But the state says she had a heartbeat in her cheek. She should remember what side of her cheek the heartbeat was in. She doesn't get that right. But how about the things when you use your everyday experiences in life that the state, they didn't talk about when he was up here talking about her injuries. He talks about her falling back and people seeing things. Okay, people can be wrong. How about things that make sense, though? We know that she's wearing sunglasses, right? We know that. Her sunglasses are not broken. She doesn't have a mark on her face from being cut by sunglasses. None of that. Is that what would happen if a 250-pound man squared up on a woman and threw a hook to her face? She doesn't have redness on her face. She doesn't have swelling on her face. She doesn't have puffiness, a bruise, or a mark. How do we know that? Investigator Schultz told us, I saw her shortly thereafter, and she didn't have a mark on her. He says, if I would have seen a mark, I would have taken a photograph of that mark. Makes sense, right? She doesn't drop her drink. She doesn't drop her vape. Her cell phone doesn't leave her bathing suit. Is that what happens when a 250-pound man squares up on a woman? She doesn't drop a thing, and she doesn't have a mark. Does that make sense to you all? Or does it make more sense that Nick Mew pushes her out of his space? Attorney Anderson said she's not in his face. Well, most of her friends said, no, she was. She was in his face. She was in his face. She was in his space. Right? If he makes this motion, she's not going to have broken sunglasses. She's not going to have a mark on her face. She's not going to have redness, puffiness, swelling, a bruise. She's not going to drop her drink because he doesn't hit her. Which one of those two things in your everyday experiences in life makes more sense? You get to decide that. And I want you to think about this. She knows the seriousness of the case. She tells the police she takes a photograph or photographs. Then she claims to have deleted them in a homicide case. Then the police say, that's okay. That happens. You give us your phone, we can get the pictures. Right? Wrong. They do a Cellbrite downloaded extraction of her phone. Investigator Schultz doesn't do it, but he reviews it and says, there's no deleted photos that I saw in there. He even goes so far as to reach out to Madison Cohen's mother. On retreat and provocation. I told you when I started, there is no duty to retreat. And that is true. That's the first sentence in the retreat instruction. If you want to, it says you may consider whether or not when he was retreating, or if he had to retreat, whether the defendant reasonably believed the amount of force used was necessary to terminate the interference. You may consider whether he had the opportunity to retreat. Okay. Now you don't have to, but when it starts, when it matters, is when he's using the force. And when he's doing that, he's surrounded. He told you he was surrounded. I asked Lieutenant Hart, do you have any information that would be contrary to Nick Mew's belief or statement that he was surrounded? She said, no, I don't. Where's he gonna go? So he doesn't have to go anywhere. We don't let people dictate what we do, and the loudest voice in the room doesn't have to win. Madison Cohen doesn't get to make these decisions for people. He doesn't have to leave. The drunk teenagers don't have to leave either. They told you they could have left, but they wanted to see the show. He doesn't have to go, and there's nowhere to go. That should be the beginning, middle, and end of that evaluation on retreat. Same analysis, same result on provocation. Okay? You have to find that Nick Mew committed an unlawful conduct against Madison Cohen to provoke this attack. He wanted her to get out of his personal space. The bully in the room doesn't get to yell at you and tell you to leave, and then when you don't leave, doesn't get to get in your personal space because you are not leaving. That's not how this works. The last part of the video is the 150 to 205 mark, okay? Now, you heard yesterday, the state wants to break this video, this last 15 seconds or so, down into stills. 1/24th of a second. No one lives their life in 1/24th of a second. And you're not supposed to in this case, because you're supposed to look at this case through the eyes of Nick Mew. And if you've watched that video, the first time I saw it, I didn't see what happened. I didn't see him pull a knife. I didn't see some of these people get injured. Because it's moving like this. When you break it down to 1/24th of a second, it's just not how we live our lives. You have to look at those 14 seconds through Nick Mew's eyes as he was standing there in the river. And remember, he told you yesterday that he believed that he was going to die. But he doesn't have to believe that. He just has to believe that he's going to suffer serious bodily injury. That's what he has to believe, okay? And before I start this video, I'm going to ask you this again. What do we know in those last 15 seconds? We know that Anthony and Dante Carlson were asked by their dad to go over there. Why? To help him. Quentin Carlson testified that he was concerned that Nick Mew was going to get the brakes beat off of him. So Quentin Carlson wanted his boys to go assist. I would submit to you that Quentin Carlson was concerned that Nick Mew was going to suffer serious bodily injury if someone didn't help him. Alex Vang told you Mew's getting his butt kicked when this is going on. And Owen Peliquin said those guys got on his ass. Right? Anthony Carlson is yelling, stop, stop, stop. He's not yelling it to Nick Mew. Nick Mew's tail down in the water. Presumably, he's telling it to the people who are beating him. Right? That's what we know. Now, Juwan Cockfield found that to be funny for quite some time. You can hear him cackling on how he thinks it's funny that Mew's getting punched in the face and knocked in the face, slapped, okay? But what we know from that video is a 250-pound man, 250-pound man, has been knocked clean off his feet backwards into the water by getting punched in the jaw. That's what we know. We know that in 1 second, Dante Carlson, who throws that punch, runs around to the other side of Nick Mew while he's still on his back, on his butt, kind of on his lower back, and he cracks him across the face. We know that. That's not in dispute. We know that A.J. Martin, who says he's the peacekeeper, that's what he said. He runs up from behind and shoves Nick Mew while Dante Carlson comes in for thirds and smacks Nick Mew in the face again. I would submit to you at this point, it's coming from all sides and from multiple people. And this man who had heart surgery is terrified as to what's going on. we know, well, let me just remind you of this. At this point, after he's been punched, slapped, pushed, slapped, he hasn't stabbed anyone. Right? And if you listened closely to what A.J. Martin said in his testimony, when he was shown the picture of him making contact with Mr. Mew before Mr. Mew stabbed him, he said, he got me before I got him, I guess. What does that tell you about what A.J. Martin's intention is? He's back in the water now for a third time after getting pushed down by A.J. Martin. And what do we see next? That's Anthony Carlson. He walks right by me. Mew doesn't do a thing to him. Mr. Mew doesn't do a thing to Anthony Carlson as he walks by. You will then see, and what we know is Anthony Carlson comes up from behind him, appears to be yelling at him and putting his hands on him. So now Mew has been touched at that point, punched, pushed from behind and slapped. And now Anthony Carlson comes up to him. We know that. And then we know 1 second later that Isaac Schumann comes up to him. You guys get to make the decision on whether or not he's choking him around the neck. You get to make that decision. I'm not telling you what that is. You get to decide if that looks like a choke to you or not. So at that point, 4 people have attacked Nick Mew. And why does it matter? Why does any of that matter? Because if you find the following, Nick Mew is not guilty of all the charges, okay? If you find that Nick Mew believed that there was an imminent unlawful interference with his person, if you believe that he believed that was coming, the 19 or 18 reasons that I put up there supports that, and he told you that. And that's his subjective beliefs, okay? If he believed the amount of force that he used was necessary to terminate that interference, okay? So if he believed that he did what he had to do, right? I would submit to you there's only 2 answers to that. Only 2 possible answers. He either did what he had to do to survive, or this man who, you watch the video, who's never got a speeding ticket, who decides to go out with his wife that day, who's floating down the river and having lunch, decides, you know what, today's the day I'm going to start stabbing people. I'm going to leave my group, I'm going to go over and I'm going to start stabbing people. Mr. Anderson says he snapped. If he was in fear, he would have left. I think anybody would dispute that he was in fear. So when you're determining whether or not what he did, if he believed that he had to do that to terminate that interference, I would submit to you, why else would he do it? He either believed that or he just lost his mind. Right? This 52-year-old engineer who's married just lost his mind that day. Those are the 2 options I think that you have on that. And the final thing that you need to decide is whether or not his beliefs were reasonable. And the standard is, would a person of ordinary intelligence and prudence would have believed standing in his shoes at that moment, okay? Quentin Carlson is about his age. And Quentin Carlson is concerned enough for his safety that he sends his boys over. Quentin Carlson tells the police that after his boys have been injured. He tells the police, I get it, they're injured. I sent them over there because I was concerned for the old guy. Brandy Hart. Did you watch that video yesterday? And that is her response. State never followed up with her on anything after that. That was her statement to the police, or that was her statement on the tape. And as I mentioned, Alex Vang and Owen Peliquin say he's getting his butt kicked. They're all over him. Are those reasonable people? You get to decide what a reasonable person would do in that situation. But I would submit to you, you've got something to work with. You've got something to work with. Briefly on the charges, okay? Before you even get to self-defense, you get to intent. You have to find intent on the homicide charges initially for Isaac Schumann, and you have to find him for the others involved, okay? And the question on intent is mental purpose. Can you watch that video and say that Nick Mew's mental purpose is to kill Isaac Schumann? Or is his mental purpose to get another person off of him? You get to decide that. Okay? Under those circumstances, you heard everybody say, anybody who never touched him, he never touched. Right? People were like, I didn't want to get near him. They didn't touch him. He didn't touch them. He didn't say anything. You get to consider all the facts and circumstances. He didn't say anything to Isaac. Right? Isaac grabs him by the throat and he stabs him one time. Is that an intent? Is that his intention to kill Isaac Schumann? And when you started this case, you heard that was the charge. Well, those charges have changed. Now you get to consider all other kinds of charges with all other kinds of mental states too, right? Maybe it was intentional. Well, maybe not. Maybe it was reckless. Pick a theory. Don't let them just throw things against the wall and hope that you guys let something stick. They're telling you they thought it was intentional. Now it might not be. Now it might be reckless. They don't have it. Nick Mew wanted to get Isaac Schumann away from him. He didn't chase Isaac Schumann down. He didn't move toward Isaac Schumann. Isaac Schumann moved toward him. And on the attempted homicides, read the instruction on attempt, you guys. In order to convict someone of an attempted homicide, the state must prove to you beyond a reasonable doubt that demonstrates unequivocally that Nick wanted to kill these people and would have, except for the intervention of another person or some other extraneous factor, okay? And unequivocally means there can be no other inference which can reasonably be drawn. No other inference. And an extraneous factor is something outside the control of Nick. You heard DA Anderson say, but for medical intervention, some of these people would have died. Well, AJ Martin would have. Dante Carlson had a hernia. He repaired a hernia. Sorry, medical intervention doesn't prevent him. He's not going to die from that. Anthony Carlson gets 2 stitches. He's certainly not going to die from it. And Riley Madison could have got an infection, they said. I understand that. But if he wanted to kill them, why didn't he? He's, if you believe Attorney Anderson, he's alone with Dante Carlson. Why does he stab him one time? He wants to kill him. Why doesn't he smash him up? He wants what he wanted all along, to get away from these people. He's leaving, and Dante Carlson, who has beaten him up, has hit him in the face repeatedly, confronts him again. What does he think? What does Nick Mew believe is about to happen? You don't have to let somebody beat you before you respond. Doesn't that make sense? And because they don't have the attempts here, because there was nothing, no outside extraneous factor, they also say might not be attempts. Take a chance on reckless. How about that? Again, not really a theory, but you get to make that decision. I'm going to comment on the video because I think it's appropriate that was played, the interview with Nick and Brandy Hart. He lies about the knife. He lies about the knife. What he and what Lieutenant Hart said is he's never wavered on is that this was self-defense, that he was fearful and that he was being attacked. Okay? That he's never wavered on that. He said it over 20 times in the interview, and it's the first words out of his mouth when he's interviewed by Lieutenant Hart. Some people get some facts wrong, some people lie about stuff. He's not telling you the truth about the knife. But does it change one thing that you saw on that video? That's the reason we want there to be a video. Is so you're not taking the word of 13 people who don't get it right. That video is not subject to change. Attorney Anderson's right. It is what it is, right? What has persevered through this case is Nick Mew's fear, how he felt, the shock. You heard people testify about that, the whiteness, the wide eyes, the ghost-looking color of his skin, that has persevered through this case. He lied about the knife. Doesn't change one thing that's on that video. You should feel sympathy for Isaac Schuman's family. I have a 19-year-old son. He would be in Isaac Schuman's grave right now. Everyone feels sympathy for Isaac Schuman's family. I'm sure he was a wonderful kid. And I know that his parents love him. But you don't get to decide this case based on sympathy. The judge tells you that. You decide this case based on facts and evidence. That's what you are required to do. And put most succinctly in terms of the burden of proof and what the state has to do is they have to prove to you beyond a reasonable doubt it's not self-defense. And what does reasonable doubt mean? Well, the judge read it to you. You'll get to hear about it again. But it's a doubt that would cause a person of ordinary prudence to pause or hesitate when deciding the most important affairs of life. And I would submit to you the most important affairs of your collective lives are your health, your family's health, loved one's health. When you're thinking about that and you have to make hard decisions on those things, if there is a pause or hesitation about what you need to do because you're getting information from various places, you say, I need a break, I need to figure this out. That's reasonable. Okay. It is a doubt for which a reason can be given. That reason is self-defense. And I just want you guys to know this. When you go back there and you have those verdict forms, if you believe it's self-defense, he's not guilty. If you believe it's probably self-defense, he's not guilty. If you believe it's possibly self-defense, he's not guilty. If you're like, it likely is, I don't know, not guilty. If you believe it might not be, not guilty. If you believe it's probably not self-defense, not guilty. All of those considerations that you would have require a verdict of not guilty. Because the state has to prove to you beyond a reasonable doubt that it wasn't self-defense. So, as I go to sit down, we, Attorney Nelson, Nick, you and I appreciate all of your time. The time that you've taken away from your families and friends to do this. The attentiveness that you've given us. And I think it's time for people to go home when you're done. And what we're asking that you do is that you send Nick Mew home. That you find him not guilty on all of the charges. Thank you.
While we swap people out, if you'd like to stand and stretch for a moment, you may do so. And then we'll hear a brief rebuttal from Mr. Smithstone.
As you just heard Mr. Tropsy say, his entire defense is based on what Nick Mew told you during his testimony was thoughts in his head, the beliefs in his head. What do we know about Nick Mew? We know he's smart, speaks multiple languages, has a couple of degrees, one's in math. He's a calculating person. He's a cunning person. He's a skilled and prolific liar. We know that because every word that came out of his mouth, practically since he started walking away from this group, was a lie, including to his best friend, who he said they took my knife while the knife is still on him. The things he said to Sheriff Knudsen, where he pretended to not know what was going on. And then everything he said to Investigator Hart, Lieutenant Hart. He is skillful at crafting a story that matches what he needs to say to avoid the consequences for his actions. We all know that. It's undisputed. He told you himself, he's a liar. All right? He did not just not How many times did he say on the stand, I don't remember, I don't remember, I don't remember? He repeated it over and over and over again because he doesn't want to answer questions about what he did because he knows dang well it wasn't justified. He's lying. He's lying. One of the many things I'm going to be grateful about when this is done is that I never have to hear again that the actions he took that day was it's despicable. There's never been any explanation from the defense as to why Nick Mew ran up on these boys, why he grabbed their tubes, why he was groping around where their legs were. They don't even respond to it. They didn't bring it up. There is no explanation. That behavior is inexplicable. He's a bizarre person. He made bizarre choices that day. It is not their fault. It is not their fault. I'll say it 100 times. It's not their fault. These boys have beat themselves up every day since this happened. You saw the raw emotion on the stand. Their best friend was murdered by this guy. And to say that it's their fault is despicable.
Previously, a few of the exhibits that were offered and admitted had some reference material on them, base numbers, et cetera, from the case that the court raised a concern. And I believe, Mr. Wood, what you've done is figure out a way to remove those references from the exhibits. And the court would note those references were not published to the jurors, and they won't be, so the court will permit those references to be removed from exhibits before they are published or provided to the jurors. Is that how we're going to handle that, Mr. Wood?
Yes, that's my understanding, Your Honor.
All right, and Mr. Pryor, any objection from the defense to proceeding in that manner with those few exhibits?
No objection.
Okay, thank you. I'll make sure then that the original court exhibits to the jurors will have that information removed before the jurors are either published the information or receive copies of it. And with that, then, I believe there are no other issues to take up before the jurors are brought in. Is the defense ready to proceed as well, Mr. Pryor?
Yes, Your Honor.
All right, thank you. Then we'll continue with testimony of this witness. And Mr. Wood, if you're ready, we'll have the jurors brought in at this time.
Thank you. All rise.
While the jury is present and counsel.
Thank you. Please be seated. We concluded the lunch break. At this time, we're continuing with testimony of Detective Hermosillo and Mr. Wood. If you're ready, you can inquire. I'll remind the witness you're still under oath for your testimony.
Thank you, Your Honor. Detective, Before we broke, we were speaking about the search of a residence. Can you remind us what residence that was?
But I believe it was apartment 175.
And whose residence was that?
Lord Gallows.
Your Honor, the state would ask that the witness be handed State's Exhibits 7A through 7K.
This is not the opportunity for persuading you or for adding new arguments. So the attorneys are not going to comment.
Culture! For the culture! Who is that? That's not Bike! That's not Bike! That's not Bike! That's not Isaac! Oh my God! Oh my God! This isn't real! This isn't real!
Anybody need to see it again? Want to see it, the entire? Or do you want to stop it at a certain point?
The witness is handed State's Exhibits 7A through K. They've been reviewed by defense. Must be reviewed to inquire.
Detective, do you recognize State's Exhibits 7A through K? Go ahead and take a minute and review them.
Yes, sir.
What do those exhibits purport to be?
They are photographs that were taken of Lord Bell's residence in the morning of November 27th.
And were you present? You testified earlier you were present at the search of that apartment on that date, correct?
That's right.
Did you walk through every room in that apartment?
Yes, I did.
Did you take these pictures?
No, I did not.
Do you recognize them as true and accurate representations of what you witnessed in that room that day?
Yes, I did.
Or, I'm sorry, in that apartment that day?
Yes, I did.
Your Honor, the state, moving for admission, states exhibits 7A through 8.
An objection from the defense.
Why do you a native objection?
Yes, and use your microphone, please, Mr. Buck.
May I judge?
Yes.
Officer, what time were these pictures taken?
I don't know the exact time, roughly between 10 and noon, I would guess.
Are you guessing or do you know?
I don't know exactly what time, sir.
Okay, who took the pictures?
I don't know who took the pictures, sir.
What day did they take the pictures?
I believe I testified November 27th, 2019.
Well, if you weren't there, how do you know if you don't know who took it or who?
Objection, he's misstating the testimony.
No, I'll allow it. You can continue to work on it.
I never once said I wasn't there. I was there the entire time on
That's not what my question was. The question was, you weren't there when the pictures were taken, were you?
I wasn't there when they were taken. No.
You don't know the condition of the home when the pictures were taken, is that correct?
I was there when the pictures were taken, not standing next to the photographer.
Okay. So you were there when the pictures were taken,
That's correct.
but yet you don't even know who the photographer was who took the pictures. Is that what you're telling me?
That's correct.
Is there a reason why you wouldn't know a photographer who's taking pictures for a police investigation that you're in charge of?
I wasn't standing next to the photographer. I was inside the residence when the photos were being taken. At the same time they were being taken, I wasn't standing next to him.
Okay, but the question I asked is, why is it that you don't know the name of the photographer when this scene was closed off for an investigation pursuant to a search warrant, and you can't tell me who the name of the photographer was who took these pictures?
There were a lot of people that were part of that search warrant. I can't tell you exactly who took the photographs.
Well, that's what my concern is.
Prior, and we're getting speaking objections now. If there's a continuing objection, state the grounds.
Okay. Well, there were a number of people that were in and out of that apartment, is that right?
In and out of that apartment? No, sir. In that apartment, yes.
How many people were in the apartment at the same time?
Roughly 10.
And you would know all of the names of the people that were in the apartment, right?
Correct.
Yet you don't know the name of the photographer who took the pictures. Is that what you're telling me?
That's what I'm telling you, yes, sir.
Judge, I'm going to object.
Your Honor, I'm going to lay some more foundation.
All right, you can lay additional foundation, and I'll also note it is a group of photographs, so if you have to work through them individually, we will. I'll note just an objection on 7A, and Mr. Wood, you can see if additional foundation can be laid before I rule on the objection.
Detective, you testified you were present that day,
That's correct.
and you recognize these images as true and accurate representations of what you saw in that apartment.
That's correct.
And is it a true and accurate representation of the condition you found the apartment in?
Yes, sir.
And as you look through these pictures, is there anything in there that is different than the way you found it?
No.
Your Honor, the state moves again for the admission.
Objection again, Judge. There isn't a proper foundation. The officer can't even tell me who took the pictures. He doesn't know what time the pictures were taken. And the condition he's talking about is the condition where he saw, not necessarily when the pictures, in the condition when the pictures were taken. So there hasn't been proper foundation here.
All right, I've considered the objection. I'm going to overrule the objection as it relates to photographs finding the officer has personal observation of the location. The one exception that I'll consider a standing objection on is on 7G, which is different, I would say, than just showing the apartment. Not saying it's not admitted, but still under advisement, pending any additional objection on foundation. So photographs, with the exception of 7G, are admitted, and you can inquire further, Mr. Wood.
Thank you, Your Honor. If I could publish those to the jury.
Yes.
Detective, can you tell me what you observed in State's Exhibit 7A?
That's the front door of apartment 175, front porch area.
And is this the apartment that you searched while you were for JJ?
Yes.
Detective, what did you observe in State's Exhibit 7B?
So as you walk into the front room of the apartment, that's looking towards the dining kitchen room area. There's a child's car suitcase sitting there. Like I testified earlier, it looked like it was lived in. There's still traps, things on the counter, paper towels, everything looked normal.
What did you observe in State's Exhibit 7C?
That's standing in the kitchen, facing the doorway, so the opposite direction of the last photograph. You can see the stairwell going upstairs. There's still pictures on the wall, TV, papers on the counter. Everything looked normal at that point as well.
You observed in State's Exhibit 7D.
So when I testified about the crawl space under the stairs and the 72-hour kits, those are a few of the 72-hour kits, along with the Star Wars suitcase that we had located.
When you, Your Honor, does the court have a pointer?
I don't know, what's up the bailiff? No, we did not, so.
For the 72-hour kits, there's some underneath here that you can't see. There's some here, and that's the Star Wars suitcase that I was referring to earlier.
Detective, what did you observe in State's Exhibit 7E?
That's the top of the stairwell, looking down towards the bottom of the stairwell. This part right here goes into the front room, and the front door is right here.
What did you observe in State's Exhibit 7F?
This is the master bedroom. So when you come up the stairwell, immediately to your left is this entrance here. Like I testified, there was bedding, pillows, everything looked normal in the room at that point. This is a bathroom as well.
Detective, what did you observe in State's Exhibit 7H?
7H is what caused some red flags for us when we were searching the apartment.
Why was that?
Because of all these empty hangars. People go on trips.
Judge, I'm gonna object this unresponsive. There isn't a question here, that's a narrative.
Sustained. Detective, I asked you why the empty closet was concerning to you.
Because when we made contact with Lori Vallow the day before, she had lived in the apartment, she was in the apartment living. The very next morning, when we served the warrant, this is what we found, empty hangars.
And Detective, why would empty hangars be concerning to you?
Because it appeared to us that she grabbed her clothes, left everything else and took off.
What did you observe in State's Exhibit 7I?
This was a bedroom. If you walk down the hall towards the west, this is the bedroom on the right hand side. This is the bedroom we found Alex Cox, some of Alex Cox's belongings in. So this is the bedroom to the right.
And what belongings of his did you find there?
There was a plastic tub with some of his belongings in, some hygiene things that had his name on them, things like that.
Detective, what did you observe in State's Exhibit 7J?
This is the same bedroom. There's one of the plastic tubs that had some belongings of Alex. There's some prescription pills up here that had Alex's name on them. And then there was some white Tyvek suits that were in the closet area.
What did you observe in State's Exhibit 7K?
This is the room to the left. So the previous room was to the right. This is the room to the left. It had twin beds, bedding, everything looked normal in that room as well.
Your Honor, I'm going to ask that the witness be handed State's Exhibit 7G again for further foundation. Very well. That's if you recognize State's Exhibit 7G.
Yes, I do.
What does it purport to be?
A rental agreement with the tenant of Lori Ryan.
And you testified earlier about finding the rental agreement, is that correct?
That's correct.
Is this the rental agreement that you were speaking about?
Yes, it is.
And where was that located in the residence?
In the master bedroom on a desk in the corner.
And you saw it there?
That's correct.
And is that a true and accurate representation of the rental agreement you saw?
Yes, it is.
Your Honor, I move for admission of State's Exhibit 7G. Any objection?
No, Judge.
All right, Exhibit 7G is admitted as well.
May I publish?
Yes.
Second, is this the rental agreement we were just speaking of?
Yes, it is.
And you testified earlier about searching the storage unit, correct?
Correct.
Was this the rental agreement that led you to that storage unit?
Yes.
Thank you. Your Honor, I'd ask that the witness be handed what's been marked as State's Exhibit 8A through 8Q. Second, I'm gonna ask you to take a moment and review State's Exhibit 8A through 8N. Second, what do State's Exhibits 8A through 8N report to be?
Photographs that we had taken in number 175 in the garage,
And what day were these photographs taken?
November 27th, 2019.
What did you observe in State's Exhibit 8A?
So when I testified earlier about various magazines, weapons, there were knives, this is where we found those items.
I just want to stop real quick to clarify, when you say magazines, what type of magazine are you referring to?
Magazines that go in rifles.
And you testified that you removed these items to take pictures of.
Correct.
And what did you observe in State's Exhibit 8A?
So here's some of the various magazines that we took out of some of the tubs. There's some ammunition. There's a few suppressors that screw on to the end of a gun to muffle the sound. There's a ghillie suit. Different items in this photo at different spots.
Could you tell me what you observed in State's Exhibit 8B?
So these were items that were located in black plastic bags, which are right here that I'm pointing to. So we simply took those items out of these plastic bags and laid them out so we can get photographs of them.
What did you observe in State's Exhibit 8C?
These are various caliber ammunition in plastic bags that were located in plastic tubs in the garage.
What did you observe in State's Exhibit 8E?
This rifle here is the exact same rifle from the previous picture. There's also another rifle that was in a bag, and that's this one here. This photograph was taken at the police department once we got the items back.
What did you observe in State's Exhibit 8F?
This is the rifle in the previous picture that was back here, just a close-up of that rifle.
What did you observe in State's Exhibit 8G?
Those are what I call the suppressors. From earlier that there was a photograph of these two men on the garage floor. This is just a close-up of both of those suppressors.
What did you observe in State's Exhibit 8H?
These are knives that were found amongst the ammunition in the rifles and tubs.
You described to the jury what you observed in State's Exhibit 8I. Okay.
This is just a handgun that was also located that was still in the case inside the garage.
did you observe in State Exhibit 8J?
This is a Halloween mask, or what we think is a Halloween mask, that was located in a plastic bag in the garage along with duct tape and rope.
You described the jury what you observed in State Exhibit 8K.
Once we remove the Halloween mask, this is the duct tape and the rope I was referring to in a Walmart bag.
Fine, what did you observe in State Exhibit 8L?
That is a passport that's located in belongings in that garage belonging to Alex Cox.
In Your Honor, I'd ask the witness be handed State's Exhibit 8M through 8Q. Well, briefly review State's Exhibit 810 through 8Q. Do you recognize those exhibits?
Yes, I do.
What do they purport to be?
These were items also located in the garage 175.
Not yet. Did you observe these items with your eyes?
Yes, I did.
And you saw these on November 27th during your search of apartment 175?
Correct.
I believe you testified they were also in the garage.
That's correct.
Are these true and accurate representations of what you observed that day?
Yes.
Your Honor, I move for the admission of State's Exhibit 8M through 8Q.
Any objection? Yes, do I hear a native objection, Judge?
Go ahead.
Officer, you previously testified that I don't want to put words in your mouth, that you staged certain items. Is that a fair assessment?
Correct.
And some of the items that you staged, when I mean staged, you remove those from packages or boxes, and you laid them out to take pictures. Is that correct?
That's correct.
Did you take pictures of all the items in the garage, or are these just selected pictures that you've decided to show today?
We took photographs of the items in the garage, anything that we thought was evidentiary value, we took photographs of.
Okay, so the question is, the answer is then that you did not take pictures of everything that was in the garage. Is that fair?
No objection, Your Honor. This is cross, doesn't build a foundation of these items.
I do sustain that. We need to get on the narrow issue of foundation for admission or not, and then we need to be allowed to cross later, of course, as provided. Yeah, any other questions on
So the
foundation?
question is that when I hear previously that you took items out of a package and you took pictures of select items, did you take all of these items out of some sort of packaging and take select pictures of these as well?
Yes, we took these out of tubs that were in the garage and took photos.
So when you were there and present going through the garage, and we don't know how big this garage is because you don't know. You couldn't see these in plain sight when you went through them, correct?
That's correct.
So you don't know what was in the garage and what wasn't. These were staged by someone else who took the pictures, is that correct?
We took these out of tubs and took photographs of them.
Who took them out of the tubs?
I couldn't tell you what officer took them out of the tubs.
When did they take them out of the tubs?
Are you asking for a time, sir?
I'm asking for a time, yeah.
Roughly 10 to 12, I would say.
In the afternoon, in the morning, when?
10 o'clock in the morning, till 12 noon.
And you were present when they were taking these out of the tubs?
That's correct.
And who took these pictures of us?
Detective O.
Judge, I have nothing else. Thank you.
All right, I'll overrule an objection on foundation relating to exhibits 8M through Q, and those will be made.
Thank you. May I have a question?
You know,
Detective, can you describe to the jury what you observed in State's Exhibit 8M?
That is what appears to be an email printed item that was located in the garage of 175. There's some handwritten scribbles on it, some names, numbers associated with those names.
And at the time that you found those documents, did you understand what that meant?
No,
Were you able to determine, you said it was an email, who the sender of the email was?
yes,
Who was it?
Daybell.
Were you able to determine who the recipient of the email was?
I don't recall the receipt. Just who sent it.
Oh, I apologize, I didn't make that down.
I just remember who sent the email.
And were you able to tell what date it was sent?
I believe it was October of 2018.
Is there a specific date?
I would have to look at it a little closer. It's in the upper left-hand corner.
Second, I'm going to have State's Exhibit 8M, if you can describe what you observed there for the jury.
It's the same photograph from the last slide.
And State's Exhibit 8O. Presume O, sorry.
That's also more of the same email papers from the last slide.
In fact, if I were to have State's Exhibit 8M attached, would you be able to tell the date of the email?
Yes.
What is the date on that email?
October 30th, 2018.
And then Detective, what did you observe in State's Exhibit 8P?
Those were also in the tab books written by Chad Daybell.
And then lastly, what did you observe in State's Exhibit 8Q?
That was a cell phone that was also found in the tub in the garage.
Were you able to look and get that cell phone at any time?
As far as forensically,
Yes.
I wouldn't be able to tell you unless I looked at the report.
Okay. Detective, we've been talking about this search on November 27th, correct?
Correct.
And at any time that day, did you locate JJ Bell?
No.
What was the next step in your investigation to find JJ?
Our next step was to talk to anybody that would take our phone calls. JJ was,
Judge, I'm going to object. This is again becoming a narrative.
Your Honor, he's still just answering the basic question.
Overruled without objection.
JJ was who we were looking for. And so we were exhausting every effort to find JJ. So we would call his siblings, family members, any family friends, anybody that might know the whereabouts of JJ.
So who were some of those family members that you spoke with?
We ended up speaking with Brandon Boudreaux, Melanie Boudreaux, JJ's brother, Colby Ryan. Gilbert Police ended up speaking with family members down there. That's who we spoke.
At any time during your investigation, did the scope of the search change to who you were looking for?
It did.
Why was that?
After we spoke with Colby Ryan, who was JJ's brother, he mentioned that he
Judge,
had,
I'm going to object. This is hearsay.
Sustained. Detective, at any time did the scope of your search change to include the search for Tylee Ryan?
it did.
And so let's go back to your search very briefly on November 27th. Did you see Tylee Ryan at that apartment at any time?
No,
And during your intermittent surveillance you talked about in early November, had you seen Tylee Ryan?
no,
Did you ever meet Tylee Ryan?
no,
Did you become familiar with who she was through your investigation?
yes, we did.
How did you do that?
After speaking with Colby, our search encompassed JJ and Tylee.
Your Honor, I'm going to ask the witness be handed State's Exhibit 5. I believe this comes in by stipulation.
It does. Judge, we've stipulated the admission of this exhibit. The counsel would be so kind as to repeat the exhibit number for me, please.
5.
Thank you.
All right, exhibit 5 has been offered and admitted. You can proceed, Mr. Wood.
Thank you. Detective, do you recognize State's Exhibit 5?
Yes, I do.
What is it?
It's a birth certificate issues out of the state of Texas.
Your Honor, may I publish that for the jury?
No objection.
Go ahead. Detective, were you able to read that on the screen?
Yes,
If you could point out with your pointer the name of the individual or who that birth certificate applies.
the name is Tylee Ashley Ryan.
And what was the date of her birth?
September 24th, 2002,
And where was she?
Travis County, Texas.
And just for purposes of the record, can you state who her father was?
Joseph Anthony Ryan Jr.,
And who was her mother?
Lori Noreen Cox.
Through your investigation, have you learned of Lori Vallow's maiden name?
Yes,
What was it?
Cox.
Okay. So Detective, you testified that at this point you were approximately when did the scope of your search widen to include Tylee Ryan?
It was after we spoke with Colby, on December 11th, 2019, we entered JJ Vallow and Tylee Ryan into what we call NCMEC, which is the National Center for Missing and Exploited Children. So on December 11th, 2019, we entered both of those children as missing and endangered.
How does NCMEC work?
It's a center where
I'm going to object at this point on foundation.
Mr. Wood, if there's any additional foundation, I agree it hasn't been.
Okay. Can you restate again what the acronym NCMEC stands for?
National Center for Missing and Exploited Children.
And is that associated with a government entity?
It is.
Do you know which entity?
I don't.
Have you ever used NCMEC before in your job as a detective?
Yes.
How have you used it before?
When we have missing children, we enter and call NCMEC, enter the information, and it goes into a database.
Mr. Wood, for the record, could you indicate what that acronym is?
Yes, Your Honor, it's NCMEC.
Thank you.
If you'd like, the detective, can you just state what that stands for again?
National Center for Missing and Exploited Children.
Did you include any other law enforcement agencies in this search?
We did. After November 27th, we reached out for assistance from the FBI. We reached out through Fremont County. So we were in contact with Gilbert Police, Chandler Police, anywhere down there where JJ or Tylee lived or could possibly be at.
And did you ever try to contact Lori Daybell in regards to the whereabouts for children?
Absolutely.
How did you do that?
We tried contacting Lori by her cell phone. We also attempted to contact.
Well, let's talk about that real quick. Were you able to talk to her?
No, her cell phone was shut off.
Did you ever attempt to contact Chad Daybell in regards to the location of the children?
Yes, we did.
How did you do that?
We attempted to contact him through his cell phone.
And were you able to get in touch with him?
No, it was also shut off.
And at any time, did Lori Vallow ever call the Rexburg police to report missing children?
Judge, objection. Foundation.
Response, Mr. Wood?
Your Honor, it's just a basic question, but I think it's in line with the question we've been going through. I don't know what additional foundation I can give for that.
Upon foundation is overruled. Witness can answer.
Did you ask that again, please?
Did Lori Vallow ever contact the Rexburg police, to your knowledge, regarding missing children?
No, she didn't.
Did Chad Daybell ever contact the Rexburg police regarding missing children?
And I'll renew my objection, Judge. Knowledge, foundation.
It's overruled.
No, he didn't.
Detective, when you place the children in the NCMEC database, you receive tips from that.
Yes, we set up tip hotlines through NCMEC, also through the FBI and through the Rexburg Police Department. So anybody with any information on those two missing children would call any one of those numbers and provide us with any information.
And did you ever receive tips through NCMEC regarding JJ Vallow, Tylee Ryan?
Yes, we did.
What would you do when you received those tips?
When we would receive the tips, we would assign it a tip number. And those tips were followed up on by detectives or other officers. So as soon as those tips came in, they were given a number and then assigned to an officer or detective to follow.
And would those tips, when they come in, do they have a phone number associated with them?
A lot of times they did have a phone number. A lot of them were anonymous. They didn't want to get involved. So some of them had phone numbers where we could follow up, others didn't.
And if someone submits an anonymous tip through nickname, is there anything you can do to follow up on that?
It depends on the information they gave us, but we would follow up with any information that they had put on the tip.
And when a tip comes in with a phone number, would you call those individuals back?
Yes.
Did you ever alert the public that the children were missing?
We did. We held a press conference on November 20th, 2019. And alerted the public that we had 2 missing children in our area.
And after that press release came out, did you receive tips after that?
Yes, we did.
And did you follow up on those tips as well?
Yes, we did.
Did any of those tips ever lead you to finding JJ Ballot?
No,
Did any of those tips lead you to finding Ty Ryan?
no.
Detective, regarding Tylee Ryan and JJ Ballot, are you aware if a child protection action was filed in Madison County regarding them?
Yes, it was.
Were you involved with that?
I was the one who wrote the affidavit.
And what was the purpose of that action?
Judge, I'm sorry, I didn't hear what the officer's response is. I was the one who wrote the affidavit. Thank you. You want me to ask questions?
I will, I just letting the witness drink the water.
I'll do shit.
Detective, what was the purpose of that affidavit?
To get Lori to produce her children to the Rexburg Police Department or the Department of Health.
And are you aware if there was an order issued in that child protection action?
There was.
What did it order?
It ordered Lori Vallow to produce her children within 5 days of being served at court order.
Detective, were you ever able to locate Chad Daybell and Lori Bell?
Yes, we were.
How did you do that?
A few different ways. Some of the tips that came in gave us location in Kauai, also through cell phone data.
Judge, can I have some foundation as to time, date, location?
Are there foundational objection, Mr. Wood?
I'll just ask some more questions, Your Honor. Approximately when did you learn about the location of Chad and Lori?
Beginning of January of 2020.
And you stated earlier, but what kind of tips gave you that information?
Eyewitnesses that would call in that said they saw Lori and Chad on the island of Kauai.
And where is Kauai?
In Hawaii.
Did you ever write warrants to aid or apply for warrants to aid you in finding Chad and Lori?
Yes.
What kind of warrants were those?
We wrote warrants for cell phone data, geofence location, a few different warrants through cell phone companies to assist us in finding Chad and Lori or their location.
And did any of the data you received from those help you locate them?
Yes, it did.
Detective, did you ever go to Kauai as part of your investigation?
Yes, I did.
And what did you do when did you get there?
I got to Kauai January 24th, 2020.
And once you got there, what was the purpose of going there?
We went there to aid and assist the Kauai Police Department in serving that court order to produce JJ Tiley to the Rexburg Police Department.
And did you see Chad and Lori Daybell in Kauai?
Yes, we did.
You mentioned assisting the Kauai Police Department in serving that order. Are you aware if Lori Daybell was served with that order?
Yeah, she was on January 25th, 2019, correction, 2020.
While you were in Kauai, did you do anything else?
We observed the Kauai Police Department serve 2 search warrants. One on Chad and Lori's condo and the other on the rental vehicle.
Did you perform those searches as well? Or just observe the Kauai Police Department do it?
No, we just observed and let them serve.
Do you recall where their condominium was located in Kauai?
I don't recall the physical address, but it was Princeville.
And is that a town or city in Kauai?
Yes.
When you observed the search of the residents they were living in Princeville, after the Kauai Police Department did their search, were you able to walk through that residence?
Yes, I was.
All right. What did you observe at that residence?
Everything looked normal. It appeared 2 adults were living there. There were beach towels, 2 beach towels, everything was in pairs. Food in the fridge, couches, everything seemed ordinary.
Did you see JJ Ballard there?
No,
Did you see Tyler Ryan there?
no,
Did you see anything that would have indicated to you that a child was living there?
no, I didn't.
Did you observe anything that would have indicated to you that a teenager was living there?
No.
Detective, to your knowledge, did Lori Vallow ever produce her children to the Rexburg Police Department or the Department of Health and Welfare?
No, she didn't.
Your Honor, I'm going to ask that the witness be handed State's Exhibit 6. Detective, do you recognize State's Exhibit 6?
Yes, I do.
What does it purport to be?
It's a photograph of Tyler Ryan.
Did you have, as part of your search, did you look at Tyler Ryan's social media?
Yes, we did.
To your knowledge, was this image obtained from her social media?
It was taken from her Instagram account.
And so as part of your search, did you personally observe her Instagram account?
Yes, I did.
And did you personally observe this image on her Instagram account?
Yes, I did.
Is this a true and accurate representation of what you observed on her Instagram account?
Yes.
And also, as part of your investigation, did you see other pictures of Tyler Ryan?
Yes, I did.
And is this individual, is that a true and accurate representation of Tyler Ryan?
Yes.
Your Honor, the state would move for State's Exhibit 6 to be entered into evidence.
No objection, Judge.
Very well. Exhibit 6 has been offered and admitted without objection, so it's in the record and
will be published if you wish, Mr. Board.
Thank you. Detective, is this the exhibit we were just speaking of?
Yes, it is.
What was the username on the account that you found that picture in?
Tylee A. Ryan.
And this individual is the Tylee Ryan that you came to recognize through your search.
That's correct.
Detective, I want to ask you about the phrase proof of life. Are you familiar with that phrase?
I am.
As a detective, what does that mean to you?
Proof of life is any documentation, any video, photograph, anything that we can use to show the last time somebody was saw alive or seen alive.
Pursuant to your investigation, did you find a last known proof of life for Tylee Ryan?
Yes, I did.
How did you locate that?
That was taken from Lori Vallow's iCloud account.
And what, do you know which iCloud account it was taken from?
Lori for style at iCloud.com.
And what was the form of that proof of life?
There was a photograph of Tylee taken at West Yellowstone.
Your Honor, I'm going to ask the state or the witness behind State's Exhibit 29A, 29B, and 13. And I believe these come in by way of stipulation.
All right. Be submitted to the witness.
And I will note that exhibits 29A and B and exhibit 13 are all admitted without objection. You can proceed, Mr. Wood.
Thank you. Detective, would you look at State's Exhibit 13? What does that report to be?
That is the photograph taken from Warrior Styles, team. They testified to earlier with Tyler and West Dallas.
If I may publish.
Yes.
You can just identify the individuals in that photograph, Detective.
Sure. The little boy is J.J. Vallow. The Tyler Ryan's in the middle, and their uncle Alex Cox is on the right.
And as part of this exhibit, did it contain metadata?
Yes, it did.
And did the metadata in this instance, well, can you describe to the jury what metadata is?
Sure. Metadata is like a time and date. It has a time and date stamp with the photograph that's taken. So it's just data associated with the photograph.
And this photo was accompanied by metadata?
That's correct.
And what date was this photograph taken?
September 8th, 2019 at 2:49 p.m.
And you testified earlier that this was in Yellowstone?
Yes,
How do you know that that's Yellowstone?
I've been there.
So you personally recognize that location?
Correct.
Detective, revisiting this idea of proof of life. Throughout your investigation, were you ever able to find photographs dated later than that of Tylee Ryan living?
No.
And can you describe just quickly where you found that photograph?
From the iCloud account associated with Lordell.
And I believe you already said it, but just for purposes of the record, what was the name of that iCloud?
Lori for Style at iCloud.com.
And how do you know that that account was associated with Lori Bell?
The information attached to it and also the photographs that were attached to it.
And when you say photographs, what type of photographs led you to believe that that was attached to Lori Bell?
Family photographs, Lori Vallow's photographs with her in the photos.
Detective, pursuant to your investigation, are you aware of a last known proof of life for J.J. Bell?
Yes, I am.
Your Honor, ask this, the witness be handed State's Exhibit 14, which I believe also comes in by way of stipulation.
From our record, again, Mr. Wood, it's been stipulated to and admitted for this. Is there an objection to the 14 being admitted?
No, Judge, it was entered by stipulation of parties.
Or 14 is admitted.
Detective, what is State's Exhibit 2?
That is a photograph of JJ sitting on a couch in what appears to be the front room of apartment 175.
And where did you locate this picture?
That was also on Lori for Style, iCloud.com.
And you mentioned you believe you recognize the location. I'm sorry, can you say that again?
Yes, it appears to be the front room sitting on a couch that was found in Morgalla's apartment, apartment 175.
And did this picture have, well, may I publish a picture? Can you just describe to the jury what you observed in state's exhibit 14?
That's J.J. Vallow sitting on the couch in red pajamas.
And did this picture, was this picture accompanied by metadata?
It was,
Is this the metadata that accompanied that picture?
yes,
What was the date of that picture?
September 22nd, 2019,
Did you know what time of day it was taken?
11:46 a.m.
And just to clarify, what iCloud account was that picture taken from?
Also, Lori for style, I thought.
So Detective, you testified earlier that, well, you testified earlier that an order was served on Lori Vallow to produce her children.
Correct.
And I believe you already testified that she did not produce her children.
Correct.
What was the next step in your investigation after that?
Our next step in that investigation was to reach out to anybody that would possibly know where JJ was.
Who would you reach out to?
We reached out to family, the FBI, other agencies, anybody that would take our calls, tips that were coming in.
Detective, while you were doing this investigation, were you aware of any investigation in Fremont County regarding Tammy Daybell?
Yes,
And what did you know? Were you a part of that investigation?
I was a part of it, but my focus was mainly JJ and Tyler.
And what was the investigation in Fremont County regarding?
A suspicious death involving the defendant Daybell's wife.
And as part of your investigation, did you know when she had died?
Yes,
When was that?
October 19th of 2019.
You testified that your primary focus was locating Tylee and JJ, correct?
That's correct.
Your Honor, we just have a very brief sidebar.
Yes.
to make every effort to be concluding trial each day at 3:30, including today. We are going to take our mid-afternoon break at this time. And just for your reference as well, in case I forget to mention, we'll be going through evidence and testimony again tomorrow, scheduled 8:30 to 3:30. And then with some scheduling issues, we are going to not be holding court on Friday. And so we'll be back on Monday. I just want to make you aware of that schedule as well. So we'll go until 3:30 today, but at this time, we will take our break. So if we can try to keep the break to 20 minutes, I appreciate it. And with that, I'll apologize for the jury.